Good morning, everyone, and welcome to Rebellious Unknown, where we make the unknown known. My name is Lynn Hurley, and I am here with you at least twice a week to discuss what is happening in this big, crazy world of ours. If you like talking all things politics, please do join the rebellion by subscribing. Don't forget to turn on the notification bell so you always get notified whenever a new show is coming up. I also do members only shows 2 to 3 times a week. And I really want you to feel like you're getting something out of your membership. And that's why we're doing that now. And it also gives us a chance to talk about things a little more in depth, a little more one-on-one. So if you don't want to miss out on those, please join us and become a member. I am so excited to be here with you this morning because this is going to be a really, really interesting day. Today we have the D.C. District Court of Appeals hearing Donald Trump's case. Today is the first day of the arguments. I'm not sure how long it's going to take. Well, I guess we'll just have to see. But it's going to be an interesting one. So this has to do with the J6 case with Judge Tanya Chutkan. And there's been a lot that's gone on in this. He's been gagged. He has appealed it. So the case itself has been stayed so far. So they're waiting to hear what the DC Court of Appeals says. And this isn't about the gag so much. This is about, I think this is about the whether or not he had presidential immunity in double jeopardy. I believe that is what they're discussing today. So we're going to see. I'm going to check because I want to make sure we don't miss it. Okay, so it looks like we're still going, but you know what? I'm going to bring this up on the screen already so that we don't miss anything that they say, but we'll keep talking until they get started. We have a couple different views, so we're going to start with this one and see how that goes. Nope. Hold on just a second. Sorry, guys. Is it not letting me go to full screen? What's going on? Hold on. Let me just refresh that and see. Oh, maybe it won't let me go to full screen until it starts. Okay. We will just keep an eye on that then. I'll do this for now, and I can see it down at the bottom. Yes, that is true. Snoopy is right. Illegal Jack is still producing discovery. So for those that don't know, because the case is in the Court of Appeals, the district court case, the original court, all proceedings are supposed to basically halt because there's been a ruling that you can't have stuff going on in the district court and the appeals court at the same time. It gets very confusing. It creates extra work for everybody. And so the judge even said, we will not be doing anything on this case until the appeals court rules. And yeah, prosecutor Jack Smith, who we know is illegal, one, because of his office itself was illegally created and appointed by Merrick Garland. But we also know that this whole indictment might be illegal because Jack Smith's appointment, he needed to, the oath needed to be resworn. So we talked about this in Jack Smith's, I think it was called illegal prosecution or something like that, another show that we did where we went through all of the paperwork. And we found that there was no original witness signature, so they had to re-administer the oath, and that was after he submitted the initial indictment, the initial court case. And so there's a big question as to whether or not this is actually even a legal case. We shall see what happens with that. I did submit that information to John Lauro, who is one of Trump's lawyers. So we'll see if they do anything with it. He did seem interested in it. So we'll see. We'll see what happens. But right now, yeah, Jack Smith is still basically kind of giving the finger and saying, I don't really care. I'm still going to be, we can still proceed with this because he really wants this case to go on as scheduled. It is scheduled, the trial is scheduled to start on March 4th, and Jack Smith really does not want to have to delay that any. So he's kind of disregarding everything that the judge has said about, we're not doing anything right now. And he's saying, well, we could still do some things. We'll just file some things here and there. And Trump's lawyers have basically said, no, you can't. You really can't. So there's that little back and forth that's going on right now. But we'll see. We'll see what happens. And today is the first day of the oral arguments. So we'll see. So right now we're just waiting. Let's just say a quick hi to everybody who is here. Let's see. Good morning, Akashi Chris from Mind Forked. How are you? So nice to see you here, Chris. Hey, Tim Freestone, how is it going? Nice to see you here too. I'm so glad you guys are here bright and early with me this morning. Hi, Nikki. Haven't seen you in a while, so nice to see you as well. Snoopies, how are you? So nice to see you. I feel like I just saw you guys not that long ago. So we watched that long trial yesterday too, or the long hearing, excuse me. So my brain is still waking up this morning. Let's see. Kevin Long, a doubter in the house. How are you, Kevin? So nice to see you here. Cindy, hey, what's up? So happy to see you here. Cindy's lurking. Chris is listening. Everybody's busy this morning, but I'm so glad you guys are here to tune in and listen. And let's see what they're gonna do. Let me double check and see where we're at. Okay. So nope, we still got about 3 minutes or so before it starts. And it may not start exactly on time, but we'll see. And like I said, I don't know exactly how long this is gonna go for, but what are you guys thinking? Has anybody been following this case? I know Snoopy's has. But anybody else, have you guys been following any of these cases? They're pretty wild. They're really interesting. There is a severe lack of due process in some of the cases, like the New York case. The judge just decided that he was guilty. He declared guilty even before the trial started. How does that happen? And the district attorney made this bogus charge and found one where, conveniently enough, didn't need a jury. So even before the case started, the judge said, yep, you're guilty. Hadn't heard any of the evidence. Trial hadn't even started yet. Still not finished, but he's already decided that the guy is guilty, even before it started. So explain that one to me. So, and there was all kinds of weird craziness going on with this one. But Tanya Chutkan, the judge in this particular case, this is the one out of DC, is she's a little bit questionable as well. So we'll see. We shall see what happens. I know people have feelings one way or the other. Some have very strong feelings one way or the other. I disagree with Kevin. I think this case actually does have valid argument. If you look at case law, if you look at history, if you look at the Constitution, this case actually the argument has quite a lot of merit. So we'll see. We'll see what the district court says. And either way, it's going to go up to the Supreme Court, because if they rule in Trump's favor, then Jack Smith, we already know he's going to bring it to the Supreme Court because he already tried. They're like, you know what? I'm just going to skip over the Court of Appeals. I know we already have something there, but hey, Supreme Court, will you listen to this case? Because let's just do this for efficiency's sake. And the Supreme Court said, no, you got to go through the process. So we'll see. And then, of course, if they rule in Jack Smith's favor, then Trump will bring it up to the Supreme Court. So either way, this case is going to be going to the Supreme Court, I'm sure. So, yeah, that's true. In the New York case, Snoopy's right. Even the bank was puzzled by the judge and his reaction. The bank was saying, we are not a victim here. Like, how could this be fraud? We are totally happy with everything that happened. We had no issue with any of this. So it is a victimless case. Yeah. The prosecutors just decided that she feels it's fraud. Regardless of anything that was stated in the contracts and the documents, she's just decided on her own that it is in fact fraud. So, that's how those things typically go. Oh, Lulu, the dog is starting already. So, oh, Kevin, you need to do your research, my dear. So yes, it was fraud. Summary judgment in the case. Okay, I'm not going to sit here and argue because the judge made the determination before the trial even started. Anyway, so Dave Hurley, hey, how are you? Smith and Garland doesn't have a leg to stand on. Whether or not they want to cheat the system and weasel out of it somehow remains to be seen. Absolutely. Just because you read them doesn't mean you understand them. Okay, so let me take a look and see how this is going. No, I'm going to, so we're still waiting. Hasn't quite started yet. Hold on, I'm going to check. C-SPAN also has it. I just want to double check and see if they have anything going yet. Nope. Okay. So we'll see which view is better, and then we'll go from there. Oh, hold on. Looks like they are, in fact, starting. So let me get this going here.
Oh yay, oh yay, oh yay. All persons having business
This is
before
just
the
going to be
honorable
audio.
the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3228, United States of America versus Donald J. Trump, appellant. Mr. Sauer for the appellant, Mr. Pierce for the appellee.
Sauer, good morning. Before you get started, can I just get a couple of things on the record? Our jurisdiction was challenged by an amicus, but from your reply brief, you are not questioning our collateral order jurisdiction.
Correct. We defend the collateral order jurisdiction. That's correct, Your Honor.
And then also, you have either abandoned or not made the Fifth Amendment double jeopardy argument before us.
We have framed the double jeopardy argument as arising principally from the impeachment judgment clause. So we haven't argued that if you go straight to the double jeopardy clause, that alone would result in reversal. We're focusing on the impeachment judgment clause. Now that incorporates principles of double jeopardy, but we haven't said a straightforward directly under the double jeopardy clause in this court at this time.
Go ahead.
Well, before that occurs, then I do want to speak to you a little bit more about jurisdiction, because we still have to satisfy ourselves that we have the jurisdiction. So even though you believe that there's interlocutory jurisdiction with respect to the collateral order doctrine, how do you place that in line with Midland's asphalt case, which specifically says in a criminal case, your jurisdiction needs to stem from the Constitution or be explicit as well in statutory law?
We have three responses to that, if I may, Your Honor. One is, of course, that if you look at the language of Midland asphalt, what Justice Scalia is discussing in that case is particularly a situation where the right is one, the legal and practical value of which would be destroyed if it were not violated before trial. And these claims of absolute immunity fall right in the heartland of that description of that right. That's been reinforced by the Supreme Court.
But how do you deal with explicitly stating that? Because we don't have an explicit communication here with respect to anything in the Constitution or statute.
Yeah, I respectfully disagree with that. The doctrine of presidential immunity arises directly from Article 2, Section 1 in the Executive Vesting Clause. It's reinforced by the plain language of the Impeachment Judgment Clause, which specifically refers to trial. Remember, what Midland asphalt is talking about is situations where the right not to be tried is at stake, and it distinguishes that from the right, the remedy for which is the dismissal of an indictment. So when you're talking about the right not to be tried, we have the clearest and most explicit reference to trial of any of the clauses in which the Supreme Court has found interlocutory jurisdiction.
But there have been other circuits that have indicated on the issue of immunity, Midland asphalt still applies.
Yeah, not presidential immunity with respect to this court.
That's what you're making your distinction.
Right. And well, what I would say is this court's decision in Cisneros explicitly says, right there, and it says most separation of powers claims may not be subject to interlocutory review, but there are some that may. And then it goes on to say presidential immunity arising from the separation of powers, citing Clinton against Jones. So Cisneros, I think, expressly contemplates that there be interlocutory jurisdiction in this sort of claim. And that's further reinforced by the court's subsequent decisions in Rose and Rostentowski, situations where the court said, look, there's a speech and debate claim, and there's also another claim it isn't derived directly from the Constitution, but it's closely akin or analogous to such a claim.
Again, about explicit, because in the double jeopardy trial scenario, you have twice put in jeopardy. So you cannot be tried again in that regard. Then in the speech and debate, it says shall not be questioned. So the language was explicit, but you're not giving me anything that says explicitly in the references that you cite.
I have two responses to that. One is the plain language of the impeachment judgment clause, which says that only the party convicted shall be subject to indictment, trial, judgment, and punishment according to law.
But
so
that
right there,
take the negative inference, correct?
The plain language supports that we've heard from the very beginning that it is the natural and ordinary meaning. The impeachment judgment clause, so that is an argument that is explicit. And I also point out that this court in Rose, in Rostentowski, in Cisneros, expressly held this is not a magic words requirement. In other words, it isn't that it's got to say right there in the text of the Constitution or a statute that this is a right not to be tried. It's that the right once formulated has to explicitly include the right not to be tried. And that's why what actually the language that's previously in Midland Asphalt is heavily emphasized by Justice Scalia is the situation where there's interlocutory appeal when it's a right, the legal and practical value of which is destroyed if it's not vindicated before trial. There's similar language in Cisneros and for all the reasons. I'd also point out that the government also has not challenged the court's jurisdiction. It has conceded.
We have to be
absolutely
secured in our own jurisdiction.
Has the Supreme Court itself referred to the Midland Asphalt as a suggestion?
I'm not aware of that, but I think
in digital equipment.
Gotcha. Yes, Your Honor. I believe Your Honor is correct about that. I think that's an excellent point, and that's reinforced by this court's case law in Cisneros, Rose, and Restentowski. Turning to the merits, if I may, Your Honor. To authorize the prosecution of a president for his official acts would open a Pandora's box from which this nation may never recover. Could George W. Bush be prosecuted for obstruction of an official proceeding for allegedly giving false information to Congress to induce the nation to go to war in Iraq under false pretenses? Could President Obama be potentially charged with murder for allegedly authorizing drone strikes targeting U.S. citizens located abroad? Could President...
So can I explore sort of the implications of what you're arguing? I understand your position to be that a president is immune from criminal prosecution for any official act that he takes as president, even if that action is taken for an unlawful or unconstitutional purpose. Is that correct?
With an important exception, which is that if the president is impeached and convicted by the United States Senate in a, proceeding that reflects, widespread political consensus, that would authorize the prosecution under the plain language of the impeachment judgment clause. Okay. So yes, with that exception.
So it seems to me that there are a lot of things that might not go through that process because it's quite a cumbersome process that requires the action of a whole branch of government that has a lot of different people involved. And so in your view, could a president sell pardons or sell military secrets? Those are official acts, right? It's an official act to grant a pardon. It's an official act to communicate with a foreign government. And such a president would not be subject to criminal prosecution?
The sale of pardons example is an excellent example because there were allegations about a sale of a pardon essentially when it came to President Clinton's pardon of Mark Rich, and the U.S. DOJ carefully and for the very reasons we've emphasized in our brief, decided not to prosecute President Clinton with that because it raised concerns about whether or not a president can be prosecuted for his official acts. There's actually an op-ed in the National Review from Andrew McCarthy.
But your position is that he can't be prosecuted for that unless he's impeached.
Yeah, that was, as long as it's an official act. I mean, in certain cases, purely private conduct under Clinton against Jones, he'd be subject to prosecution for that so long as he's not in office. But as long as it's official.
Could a president order SEAL Team 6 to assassinate a political rival?
Several different voices asking.
That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders are much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist Number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted? And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached and convicted first.
My question was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons could sell military secrets, could order SEAL Team 6 to assassinate a political rival.
Sale of military secrets strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not prosecuted.
But your brief
So-
says that communicating with an executive branch agency is an official act, and communicating with a foreign government is an official act. That's what presidents do.
They're very strong situations. There's very strong examples of potential official acts. If you look at what Chief Justice Marshall said against Madison, he said, rising directly under Article 2, Section 1, that the courts, that the president's official acts are, quote, never examinable by the courts. And he says it like 4 different times on pages 164 to 166.
Well, let me ask you about that then, counsel, because your position is, as I understand it, if a president is impeached or convicted, impeached and convicted by Congress, then he is subject to criminal prosecution, correct?
That would be a necessary, said to prosecution.
Is that a yes?
Yes. Yes.
Okay,
You're
So
going to
therefore,
judges
he's
ask a lot
not
of scenarios because they're trying to look at
completely
everything
and absolutely
before they make a ruling on anything.
immune, because under the procedure that you concede, he can be prosecuted if there's an impeachment and conviction by the Senate.
Very, very formidable structural check against the astonishing radical action of prosecuting a former president with official acts.
Correct, but you're conceding that presidents can be criminally prosecuted under certain circumstances.
Specifically, if they're impeached and convicted, I think that's the plain language of the impeachment judgment clause.
And isn't that also a concession that a president can be criminally prosecuted for an official act? Because presidents can be impeached for official acts.
Under those unique circumstances.
Correct. But given that you're conceding that presidents can be criminally prosecuted under certain circumstances, doesn't that narrow the issues before us to can a president be impeached? Can a president be prosecuted without first being impeached and convicted? All of your other arguments seem to fall away. Your separation of powers arguments fall away. Your policy arguments fall away if you concede that a president can be criminally prosecuted under some circumstances.
I disagree with that. The Constitution in the Article 2, Section 1 vesting clause, as interpreted very clearly by Chief Justice Marshall and Marbury against Madison, says Article 3 courts lack jurisdiction to engage in examination of the president's official acts. That's
But
been
you just
reaffirmed by
conceded that Article 3 courts can do so if he's been impeached and convicted.
the Constitution makes a carefully balanced, explicit exception to that principle in the impeachment judgment clause. So the problem for the separation of powers, the Constitution does this in many other situations where it engages in a balancing. What the framers were most concerned about was not the notion that the president would never be prosecuted for things that outrage his political opponents. What they were concerned about was politically motivated prosecutions. But they didn't say the president can never be prosecuted. They set up the
Correct.
separation of powers and they created a very narrow exception
Correct,
that would
but-
allow prosecution in those cases.
But once you concede that there's not this absolute immunity, that the judiciary can hear criminal prosecutions under any circumstances, you're saying there's one specific circumstance, then that means that there isn't this absolute immunity that you claim.
I'm not aware of any case or constitutional doctrine that would say the Constitution sets up a very strong principle and it creates a very narrow exception, and therefore the exception just makes the principle vanish. I just disagree.
That's not what I'm asking you. I'm saying that you're coming before us and saying that there is this absolute immunity
I know.
that is grounded in the separation of powers, that the judiciary can never sit in judgment on what the president is doing. But you're conceding that that's not true because under some circumstances, the judiciary can do that. That's all I'm saying.
I think that repeat and answer, which is a very strong principle in the separation of powers that prohibits Article 3 courts from sitting in judgment over a president's official acts. There's a very narrow exception for conviction after
I
impeachment.
understand.
And that's
But
the position.
it just seems to me that if once you concede that presidents can be prosecuted under some circumstances, your separation of powers argument falls away. And the issues before us are narrowed to, are you correct in your interpretation of the impeachment judgment clause? Does the impeachment judgment clause actually say what you say it says? That's all that's really we need to decide.
I respectfully disagree with that. I respectfully disagree with it. There is a strong principle. It's reinforced by Chief Justice Marshall in Marbury against Madison. He did not say we can never sit in judgment over a president's official acts, but because it can be impeached and convicted, therefore we can do it whenever we want to. He said the exact opposite. He says they are never examinable by the courts.
So
And
are
that's
we answering the larger question about whether there's presidential immunity from criminal prosecution for official acts? Or are we looking to a standard on a motion to dismiss, which says, look to the allegations, take those as true, and then look to whether or not we should be looking at official acts in that lens?
actually both threshold question raised by the district court judgment is essentially there's no such thing as criminal immunity for a former president, and therefore the district court never reached the second issue, which is if you actually look at the face of the indictment, are these all official acts? We have strong arguments on both of those things. The notion that criminal immunity for a president doesn't exist is a shocking holding. It would authorize, for example, the indictment of President Biden in the Western District of Texas after he leaves office for mismanaging the border allegedly, and let a Texas jury and Texas judge sit in judgment over the validity of his
But you
acts.
also indicated earlier that when there were pardons or when people were not prosecuted, not everybody goes through an impeachment proceeding before they actually get prosecuted, because that's within the discretion of the prosecutor.
Only for subordinate officers. So as the OLC amendment points out very clearly, the founders, the framers actually in the Constitutional Convention clearly contemplated that that sequence that I've described would be mandatory. He would have to be impeached and convicted first before you could go on
But
to.
impeachment also only deals with certain crimes: bribery, treason, high crimes and misdemeanors.
Yeah, and if you look actually at what is said in the Federalist number 65 by Hamilton about that, high crimes and misdemeanors basically cover anything that the U.S. Senate makes a political judgment justifies removing him from office and authorizing
But a
prosecution.
prosecutor is impartial, does not make political judgments, assumingly, to charge.
I think that it has no basis in the context of the current prosecution, where the current incumbent of the presidency is prosecuting his number one political opponent and his greatest electoral threat in this particular.
Asking you from the standpoint of what the impeachment judgment clause is designed to do, that it limits itself to certain acts, and then therefore, and if convicted, as you indicated, impeached and convicted, thereafter could be prosecution. But not everybody goes through that process. And of course, it's limited to the certain actors in that regard, but not everybody has to go through that process. Prosecutors later on can come into information and evidence after they've investigated to make their determinations about what they'd like to criminally prosecute. So you're not always confined to whatever would be in the impeachment judgment clause.
Whatever the practice has been with respect to subordinate officers, the evidence from the founding generation is clear as you cannot do that with respect to the president. Right? And this is one example of many that's reinforcing all the Supreme Court's case law, the uniqueness of the presidency and the person who occupies the office of the presidency. So, for example, you get repeated statements in Nixon against Fitzgerald. It's reaffirmed in Trump against Mazars, reaffirmed in Trump against Vance, and so forth about the unique nature of that particular office.
But
and therefore,
even under Clinton, where there's a deal cut, under President Nixon, where there's pardon given, there's an assumption that you could be prosecuted, because why enter into those particular acts?
those examples are examples of purely private conduct. For example, Clinton against Jones makes very clear that the stuff that President Clinton cut an indictment deal about by admitting to certain wrongdoing in exchange for not being indicted was purely private conduct. Nobody has contended that the president's immune from prosecution for purely private conduct. It's a question is, can he be indicted for official acts? And you referred to the pardon of President Nixon. We have two things to say about that. President Nixon was accused of a wide range of purely private conduct. He was facing potential indictment for that at the time the pardon was issued.
Back to purely private conduct. If we go to the indictment, they are not alleging purely, they're alleging that this is private conduct, but it's subject to fraud, not official acts. So why don't you speak to that, since you said that we have to look at the broader question as well as the indictment?
Yes, Your Honor. So the allegations in the indictment allege only official acts. The only way to even characterize them as private acts is to turn to the alleged motive or purpose for them. So their whole theory, their characterization of the language in the indictment is, oh, we're alleging purely private conduct because it was engaged in for particular purposes. And that's foreclosed by a very long and strong line of Supreme Court
How does the
precedents.
Blasingame case fit here, that this circuit distinguish office seeker versus office holder in terms of how you're committing the acts.
This Blasingame strongly reinforces what was said, it's been said in Supreme Court cases in Stump against Sparkman, going back to, for example, Marbury against Madison, where it's the nature of the act itself. I understand the Blasingame opinion to reinforce that by saying it's an objective. They use the word objective multiple times. Objective, context-specific assessment. It does not turn on the purpose or motive. That was strongly pushed in Blasingame, and this court properly rejected. That's consistent with Nixon against Fitzgerald, Bradley against Fisher, Spalding against Vilas, Judge Hand's opinion in Gregoire. I mean, that's the strongest principle of law in this context.
I'll turn to my colleagues because I've taken up your time, but we'll give you what you need. With respect to the actual indictment, it does not gloss over what, and put it in terms as you're describing. So if we look at the face of the indictment as to what's charged, when it's gone through a grand jury process, unlike the impeachment judgment clause, how do we look at those particular acts as described? Because we have to take those at face value.
There's clear guidance on this from Nixon against Fitzgerald, where Nixon against Fitzgerald, the allegation was President Nixon had unlawfully terminated a whistleblower, essentially. And that whistleblower came into court and says, this is not subject to immunity because it was unlawful. And the court said, we're not looking at that granular level of detail, and we're not considering, most importantly, the alleged motive for these acts. It said that the level of specificity to consider it is conducting the business of the Air Force. Similar here, if you look at the indictment, there's 5 classes of conduct that are alleged, many of which are just obviously official conduct. Meeting with the U.S. Department of Justice about who should be the cabinet level officer running that. Is it the heartland of the appointments power?
You said many of which, so not
really all of which. I mean, Arcanich is all, which is one exception because there's allegations about the Elib speech, and under Blasingame, the contention was made that they should be remanded for that. But if you look at the other public statements, for example, President Trump's tweets, the Second Circuit held in Knight First Amendment Center that it was based on overwhelming evidence. That's an official channel. His Twitter account during the presidency was an official channel of government communication, and under the objective test in Blasingame, all those tweets are obviously immune. So also with meetings with the Department of Justice, meeting with members of Congress, that falls right within the heartland of Article 2, Section 3, which authorizes the president to communicate with Congress about the matters that he views as expedient.
Let me ask you, first of all, I don't believe you were counsel then, but what about the 2 concessions made in the first impeachment proceeding and then in Trump v. Vance, that impeachment should be stayed and wait until he's out of office when he would be subject to criminal liability?
As to Trump against Vance, it was a purely private conduct that involved a subpoena, a criminal subpoena for tax records that long predated President Trump's time in office. So it was purely private conduct. The concession that he could be subject to prosecution is also correct. As for the impeachment brief, for example, that they've cited in their briefs, what that says is we have a judicial process in this country, period. We have an investigative process in this country to which no former officer is immune. It did not say there could never be raised an immunity defense. It said criminal process can go forward.
There's a quote in the congressional record in which your client said through counsel, no former office holder is immune from investigation and prosecution.
Investigation is what there's no immunity to. Well, that may be true of subordinate officers, but as to the principal officer, the president, he is immune unless he is impeached and convicted. Again, it comes back to the point
he was president at the time, and his position was that no former office holder is immune. And in fact, the argument was there's no need to vote for impeachment because we have this backstop, which is criminal prosecution. And it seems that many senators relied on that in voting to acquit.
That relies on speculation. Said, I think, statement. The court, I think, lacks the ability to intuit what motivated senators' votes in the impeachment process. What the Constitution says is you must be impeached and convicted.
The question that Judge Henderson was asking you was, you took the position, or your client did, during the impeachment proceedings, that there would be an option for criminal prosecution later, and it's in the congressional record. And I guess the question is, what has changed, or why have you changed your position?
To agree with that characterization of the statements in the congressional record, I believe there was a distinction between the judicial process and the investigative process. That was in the quote that I just read. In addition to that, whatever concession may or may not have been made there would not have a res judicata effect in this proceeding. These are very different proceedings. And again, the notion that no one is immune from the judicial process, and the judicial process should go forward, is fully consistent with the notion that defenses, including presidential immunity, which again is rooted in the separation of powers, could be raised in those processes. So the notion that there could be a criminal process and then defenses like this could be raised in that process is I think, pretty straightforward. There's no concession that there's no such thing as criminal immunity. There's no concession in those proceedings that what the district court in this case did, the very kind of astonishing holding that no president is criminally immune from prosecution, is just, I think it's not there in the congressional record.
Let me go back to Marbury versus Madison, and you isolated that one sentence. Isn't it true that the progeny of Marbury versus Madison has distinguished between discretionary official acts and ministerial, by which they mean imposed by law? And that it's the latter one in which he can be held liable. And I want you to address both U.S. v. Johnson and the Commonwealth of Virginia, because the first one deals with the speech and debate clause. And the Supreme Court said, in essence, lop off all of the evidence dealing with the speech and debate. He can still be prosecuted, that is, that congressman, or I think it was conspiracy to defraud the U.S. or something. And then in the Commonwealth of Virginia, you had the judge who had been charged with a crime under which you could not discriminate in picking juries based on race. And my reading of that case is that the language that you isolate in your reply brief, that it could just as easily be done, that is the choosing of the jury, a ministerial act by someone on the street. To me, that means when you have a duty that is imposed by law, picking a jury, they said was ministerial, imposed by law. Whether you're the man on the street, whether you're the president, whether in that case you're the judge, you can be held criminally liable. And that's how I read, if not Marbury, the progeny. That is, you can't stop at official act. You have to say, was it a discretionary official act or was it a ministerial?
I agree with that characterization of Marbury. I think that distinction is present in Marbury itself. And I think what I would respond to that is to say, first of all, that extension has never been extended up to the president, and for good reason, because for over 200 years, the courts have held we can't sit in judgment over the president's official acts under any circumstances. So, for example, Mississippi against Johnson.
Not criminal. We don't have any criminal.
That's correct. It's never arisen until this case. That is absolutely correct. But if you look at every civil context, what they've said, you keep in mind that what Chief Justice Marshall says is never examinable. Never examinable. So there would be no judicial proceeding where you could say the president did this and we're going to sit in judgment directly over that. That's reinforced by Mississippi against Johnson, by Swan against Clinton from this court more recently, where the courts hold that we can't even enjoin or even really enter a declaratory judgment directly against the president for his official acts. Whereas the distinction between ministerial and discretionary has been held totally with respect to subordinate officers, and that goes all the way back to Marbury. However, if you look at the indictment in this case, nothing that's alleged against President Trump could remotely be described as ministerial. I'm not aware the government has ever argued that. If you're talking about, responding to widespread allegations of fraud, abuse, and misfeasance in a presidential election, trying to find how to respond to that in a manner that's in the national interest, matters of that nature are not ministerial at all. So even if that distinction goes all the way up to, so to speak, it wouldn't save the indictment here.
Why isn't it his constitutional duty to take care that the laws be faithfully executed requires him to follow those laws, every one of them?
Yeah, nothing. I would say that the take care clause, carrying out one's duties in the take care clause, are inherently discretionary. An example of a ministerial act, for example, in Marbury against Madison, is like delivering a seal when you're requested, because there's a separate statute. Right. What they emphasize is there's a separate statute. The Secretary of State had kind of these two hats on. He was, on one hand, a direct agent of the president in that This could never be examined by the courts. On the other hand, the original statute had imposed all these like purely ministerial duties that had to do with record keeping and delivering documents. Like if you got a land deed that's got a seal on it and the person asks for it, where there's no discretion at all. When you're talking about the take care clause, there's no statute that could impose on the president a mandatory duty to engage. I mean, the notion that when the president's meeting with the Department of Justice, for example, saying, hey, we should investigate and enforce federal fraud statutes, the notion that that's ministerial strikes me as insupportable.
Well, I think you're missing what I'm asking, which is, I think it's paradoxical to say that his constitutional duty to take care that the laws be faithfully executed allows him to violate criminal laws. Now, we're at the motion to dismiss stage. The government has charged the specific criminal laws. We have to assume they're true.
I mean, my response to that, I think, would be to emphasize what Chief Justice Marshall said in Marbury, which is that they can never be examined by courts. That naturally includes a criminal proceeding.
But I thought you agreed with me that we've gotten beyond Marbury in the sense that official acts has been subdivided into discretionary and duty-bound or ministerial. And in the ministerial or duty-bound, at least with respect to even legislators and judges, they have been held criminally liable. And that's in the face, at least with respect to the legislators, of an explicit constitutional privilege.
Yeah, I don't view United States against Johnson and even ex parte Virginia as resting on the ministerial versus discretionary distinction. I think what Johnson says is, it doesn't say, hey, when you were doing these other things, they were ministerial. What it says is these were not legislative acts. Right. And so it draws a distinction between legislative and non-legislative acts. So also, I think that's the right reading of ex parte Virginia. They go on to say judicial act. In other words, the argument that picking a jury, I don't even believe they use the words, my recollection, ministerial. They say that
because they were criminal acts. They were criminal acts. Picking the jury based on race is a criminal act. And whatever Johnson did, I think it was the very same statute, fraud against the United States, that is before us today.
I would say that the distinction in those cases is between, in the judicial case, Johnson, legislative case, Johnson, is between legislative acts and non-legislative acts. The distinction in ex parte Virginia is between judicial acts and non-judicial acts. That phrase is used. And here, the distinction is between presidential acts and non-presidential acts, and everything that's alleged in the indictment is a presidential act. Your Honor, I see.
May I? There are a number of precedents or cases in which the Supreme Court has reviewed actions by the president. The seminal case of Youngstown Sheet and Tube, where the Supreme Court reviewed Harry Truman's seizure of the steel mills during the Korean War. There's also the case of Little versus Bareem, where Chief Justice Marshall reviewed the actions of President Adams when he seized certain vessels. Trump versus Hawaii was reviewing President Trump's order restricting the entry into the United States of nationals from certain foreign countries. How does that square with your position that the judiciary can never review executive action?
All those cases fall squarely within the well-established exception in Ex parte Young, where the judiciary is allowed and does frequently issue declaratory judgments, injunctions, judgments against subordinate officers.
These are presidents. These are presidents. Harry Truman was the president when he seized the steel mill. How does that comport with your theory?
In that case, was an injunction against the Secretary of Congress, not against the president. This court has reaffirmed very recently that you cannot issue an injunction directly against the president. The court has no jurisdiction to do that. Cannot enter. It strongly indicates in Newdow against Roberts that the court can't even enter a declaratory judgment.
The court can review presidential action if, on paper, they direct their judgment to a subordinate officer. Is that what you're saying? Because these are presidential actions.
The court can definitely enjoin the actions of subordinate officers that violate the Constitution. That is Ex parte Young. All the cases fall within.
I'm asking you a different question, because these are presidential decisions, presidential actions. And you're saying that the court can review presidential actions as long as when they issue the judgment, they issue it to a subordinate.
indirect context. It can't directly sit in judgment over the president's official acts. It's been established for over 200 years.
You're using the impeachment judgment clause essentially as a negative implication with respect to that the civilian officer or president, of course, has to be impeached and convicted, and then nevertheless thereafter. If there is an acquittal, how are you using it in that regard? Because sometimes, and particularly in this case, the acquittal can arise from lack of jurisdiction, not actually trying the merits of the case.
The impeachment judgment clause doesn't distinguish between those sort of merits-related acquittals and non-merits-related acquittals. Frankly, the same sort of thing comes up in just criminal prosecutions under the double jeopardy clause, where a determination that the defendant is acquitted does not necessarily reflect an actual determination that they're not factually guilty. And in fact, this is emphasized in the OLC memo that they themselves address, that actually, that determination often reflects things that are distinct from the merits. So that doesn't, I think, in any way undermine the sort of double jeopardy force, so to speak, of the impeachment judgment clause.
And one of the briefs indicated that Jack Smith is improperly appointed. Do you have a position there?
It's a very persuasive brief, but I can see we have not raised it in this case. I think it raises very powerful questions, but we haven't raised it in this case at this time.
Just about the effect of blasting game. If we say we can't determine if these acts are official or private, I want to stay away from that. I'm going to say ministerial or discretionary. And blasting game characterizes it in terms of office seeker versus office holder. What is your position about, would we have to remand it for the district judge to decide in the first instance whether these the 4 points that the defense has made against imposing criminal liability hinge on whether the acts are ministerial, discretionary, official, private, however you want to characterize it?
I use the phrase from Clinton against Jones, which says purely private conduct is what can be, subject to judicial process after a president leaves office. In response to your question, our principal position is you can look at this indictment and it alleges official acts and it can be ordered to be dismissed. We acknowledge, though, that the district court didn't reach that issue, and Blasingame did remand, and the court absolutely has the discretion to remand to the district court for the application of the doctrine of criminal immunity in the first instance. And we admit that that would be a natural thing for the court to do.
To the specific acts.
Correct. Yeah. In other words, if the court holds that there is presidential immunity, which it should, then remand to the district court to say, okay, go through the indictment or else hold factual findings and so forth to decide how it applies to the conduct alleged in this case. We acknowledge that would be, the court has the discretion to do that, and that would be a natural course. And if there are no further questions.
I have one more question. So under the framework established in or discussed in Nixon versus Fitzgerald, we're supposed to conduct a balancing test where we balance the need for the asserted immunity versus other public interests. And I see you as trying to represent a need for the executive to have this immunity to facilitate executive functions, the ability to act without hesitation, to be fearless, to make decisions without being inhibited by the fear of criminal prosecution. But it seems to me that there are some other Article 2 interests here that are countervailing. For example, under Article 2, there's an executive vesting clause. And so there is an interest of the executive branch as an institution to have constitutional executive power vest in a newly elected president. There's also an executive interest as an institution in law enforcement, in enforcing criminal laws. And so it seems to me, if we're weighing executive interests versus public interests in things like the integrity of an election, that President Trump's position is not fully aligned with the institutional interests of the executive branch. And in this balancing test, that weakens the executive power that he's trying to assert.
I say three things in response to that. First of all, Nixon against Fitzgerald emphasizes that the most compelling consideration when one considers what it describes as policy considerations rooted in or in the separation of powers is the rendering of the executive branch official unduly cautious in the exercise of highly controversial and sensitive decisions that come up all the time. If a president has to look over his shoulder or her shoulder every time he or she has to make a controversial decision and worry, after I leave office, am I going to jail for this? When my political opponents take power, that inevitably dampens the ability of the president.
I understand that that's your position, but I guess I'm asking you, what about other Article 2 interests? That's one interest, but there are other Article 2 interests in play here too, and they seem to be countervailing. The interest in executive vesting, the interest in law enforcement, those are also executive branch interests. And how should that affect the analysis?
Those, to the extent the court conducts a balancing, our principal positions, you can go back to Marbury versus Madison and adopt a categorical rule, which is also referenced in Nixon against Fitzgerald. But to the extent the court reaches the balancing of policy considerations, those are decisively outweighed by the sort of republic shattering consequences of subjecting our chief executives in an endless cycle to prosecution once they leave office. The founders were very much against that. They were deeply concerned with that. You see that in Hamilton's writings in Federalist 65, 69, and 77. You see it reflected in Madison's concern about newfangled and artificial treasons in Federalist 47. And that is the original meaning of the Constitution.
Do you think we should, it just occurred to me, do you think we should take any cognizance of the fact that when they wrote that, George Washington was the president? I mean, a very, very strong executive. The Congress was brand new. Everything else was brand new. And things have balanced out. I mean, we've got a strong Congress, we've got a strong judiciary, and we've got a strong president.
I think that if you look at the writings of the founders, they were definitely looking past the presidency of George Washington, obviously an iconic figure, looking past the presidency of George Washington to future presidencies. And they correctly anticipated that the nation might, what they were deeply concerned about was that the nation would devolve into factions. Factionalism did not govern the presidency of George Washington because of his moral authority. However, immediately when you got to Adams and Jefferson, you immediately devolved into factions. They correctly anticipated and were deliberately looking past that presidency to the future of the republic, a tradition that stood for 234 years until last year when it was shattered by the indictment of President Trump. And if the court has no further questions, we would ask the court to reverse. And if the court rules against us in any respect, we renew our request that the court stay its mandate to allow us to seek further review, both en banc and or Supreme Court review.
And you give that 5 minutes.
Thank you, Your Honor.
Okay. Mr. Pierce.
Good morning, and may it please the court. Never in our nation's history until this case has a president claimed that immunity from criminal prosecution extends beyond his time in office. The president has a unique constitutional role, but he is not above the law. Separation of powers principles, constitutional text, history, precedent, and other immunity doctrines all point to the conclusion that a former president enjoys no immunity from criminal prosecution. At a minimum, this case, in which the defendant is alleged to have conspired to overturn the results of a presidential election, is not the place to recognize some novel form of criminal immunity. Now, I want to start with jurisdiction, as Judge Childs raised. It is our view that the court has and should entertain both claims before it. With respect to the immunity claim, I think this court's decision in Cisneros 10 years after Midland Asphalt did allude to a type of separation of powers claim that would involving presidential immunity. I think Judge Henderson pointed out the Supreme Court itself has acknowledged that this idea of an explicit guarantee is more of a suggestion than some sort of statutory prescription.
But there's been no cases since then that have actually used that word suggestion to follow up on that line of thinking.
Within the Supreme Court, I don't believe there have been cases, but certainly this court in Cisneros, as well as in cases also post Midland Asphalt, like Rose, Rostenkowski, and Durenberger have recognized that this type of a separation of powers claim when you're talking about immunity is something for which a collateral order, appellate jurisdiction on a collateral order theory is
And
available.
there are also other circuits, I think it's 1st, 2nd, and 10th, that keep following that line of thinking with respect to Midland's Asphalt. It requires an explicit constitutional or statutory language that says you cannot be tried.
So two responses. One, I think in cases like Cisneros, this court has spoken otherwise, but nonetheless, I think the only one there is the First Circuit's decision in Joseph, where it was the case of a judge seeking a criminal, raising an immunity defense to a criminal prosecution. As this court acknowledged in both, I believe, Rostenkowski and Durenberger, that's in some tension with, or it didn't acknowledge that, but the case, the court there talked about Claiborne and Hastings, which are 9th Circuit and 11th Circuit cases. I think Judge Easterbrook, in his shock opinion, noted that when it deals with a personal immunity like that, it's different than the kind of transactional immunities that were considered in the 10th and the 2nd Circuit cases. And at the end of the day, I think we do, so sort of a small point of common ground between us and the defendant. We do think that with respect to jurisdiction, there is a little bit of a different inquiry with respect to a president. We don't think that carries over to the merits in the least. And I think United States versus Nixon is sort of the perfect example of that. There, the court said it would be unseemly to hold the president, to require the president to go into contempt. Nonetheless, reaching the merits, of course, rejected President Nixon's absolute executive privilege claim and required that the—
You don't see a distinction on the civil versus criminal context, because the cases I'm referring to are civil, criminal cases.
So I don't, and Rose said as much here when talking about civil and criminal with respect to speech or debate. And again, I mean, I know this Nixon versus Fitzgerald is a civil case, and we strongly disagree that it should be applied here for many of the reasons that Judge Pan set out. But I do think with respect to the immunity, again, given the language in Rose, that would supply basis for this court to entertain the immunity claim.
But
Now,
why aren't you taking the position that we should dismiss this appeal because it's interlocutory? Doesn't that advance your interests?
Our interests are twofold. One, as in United States versus Nixon, it is doing justice. And then the second is indeed to move promptly to satisfy and vindicate the public's and the defendant's interest in a prompt resolution of this trial. But doing justice means getting the law right. And it's our view that even if a dismissal on jurisdiction might move this case faster, actually empirically that's hard to know, we just don't think that's the right analysis here on either immunity or the second claim.
So we have a line of cases, including Kramer versus Gates and American Hospital Association versus Azar. It says that we can assume hypothetical statutory jurisdiction and reach the merits of a case. Statutory jurisdiction being distinct from Article 3 jurisdiction, which we could never assume because that implicates the power of the court to act. So if we had discretion to reach the merits versus just dismissing this case under Midland Asphalt, which I think is a strong precedent, which suggests that this appeal is interlocutory and does not fall under the collateral order doctrine. How should we determine how to exercise that jurisdiction about whether or not we should reach the merits?
So I think in the American Hospitals decision, the 2020 decision, the court said the formulation was something like, we're doubtful as to our jurisdiction, but nonetheless, invoking the line of cases you've just described, went on to decide the merits. We would urge the courts to do the same here, even if it entertains doubts with respect to the jurisdiction. Yes, hypothetical statutory jurisdiction is available under the law of the circuit. The court should use that to reach the merits.
But doesn't that lead to a hypothetical decision and an advisory opinion?
No, I think so we disagree.
The Supreme Court has said that.
No, I don't think the Supreme Court has said that. I mean, the Steele Co. is kind of the leading Supreme Court decision, and then some courts, including this court, has devised a hypothetical statutory jurisdiction doctrine. Now, if this court were to dismiss for lack of jurisdiction and then say, nonetheless, as an alternative holding, here's how we would come out on the merits. That I think would be improper. That is what I understand the American Oversight Brief to be suggesting at footnote 11 on page 20 of its brief. That I don't think is something the court could do. I understand the hypothetical statutory jurisdiction piece to allow the court to say, you know what, this is hard. There might be arguments on both sides. We think that we assume hypothetical statutory jurisdiction. We move forward. We decide the merits. Now,
Let me ask you about Marbury versus Madison. What's your interpretation of its progeny, or even the case itself?
So our interpretation is much closer in line with what I think I heard Judge Pan setting out, and similar to yours. It certainly does not erect a unreviewable power for the presidency. I think the sort of the prime example of that is the steel seizure case, the Youngstown case. That was President Truman closing the steel mills. That was the court coming in and reviewing that. We see that all the way through to the present. And so it's hard to see any world in which the court just says, we can't intervene here. We do see, I accept the court's, Judge Henderson, the distinction between sort of ministerial and discretionary acts. Compliance with the law is not some sort of discretionary call, right? It is something that I fully endorse or agree with the idea of the paradox of a president, on the one hand, having the Article 2 take care responsibility, and on the other hand, sort of seeing the law as compliance with the law as optional.
Let me switch. Ask you, how do we write an opinion that would stop the floodgates? Your predecessors in their OLC opinions recognized that criminal liability would be unavoidably political.
So a couple of responses. For one, of course, that was with respect to a sitting president. I think the analysis is extraordinarily different with respect to a former president, which OLC in that very same, I'm sorry.
But not with respect to being necessarily political.
Well, I think there is a political process which is impeachment, and we can talk about that, but there is a legal process which is decidedly not political. And that is a process which has the kinds of safeguards that a couple of members of the court here have already referred to. We're talking about prosecutors who follow strict codes and who are presumed to act with regularity, grand jurors, pettit jury eventually, and this court sort of standing, Article 3 court standing above it. But I also want to push back a little bit against this idea of a floodgate. At least since the Watergate era, 50 years ago, has there been widespread societal recognition, including by presidents and the executive branch, that a former president is subject to criminal prosecution. And Nixon was not about private conduct. Nixon was about, among other things, using the CIA to try to interfere with an FBI investigation. He then accepts a pardon, understanding that after having resigned, right? So again, I think that also undermines this impeachment first argument. After Nixon, we then see a series of independent and special prosecutors investigating a range of different types of conduct. You saw independent counsel Lawrence Walsh in the Iran-Contra affair. That's an example that the defendant invokes in his reply brief. In chapter 27 of that report, the independent counsel assumes that President Reagan is subject to prosecution and says, but we didn't get there evidentiarily, right? There were not that we thought there was some sort of immunity. And that has continued through to the present. And so this notion that we're all of a sudden going to see a floodgate, I think again, the careful investigations in the Clinton era didn't result in any charges. The fact that this investigation doesn't reflect that we are going to see a sea change of vindictive tit for tat prosecutions in the future. I think it reflects the fundamentally unprecedented nature of the criminal charges here. Never before has there been allegations that a sitting president has, with private individuals and using the levers of power, sought to fundamentally subvert the democratic republic and the electoral system. And frankly, if that kind of fact pattern arises again, I think it would be awfully scary if there weren't some sort of mechanism by which to reach that criminally.
In your brief, you raised some sort of lesser immunity potentially applying. Want to speak to that?
I do. We don't think that's comes into play here. I think the point was, in some sort of more challenging cases, it might be that where a president is operating under extraordinary time pressure, has to make a very difficult kind of national security type of decision. You know, do I go in and commit this kind of, do we order the drone strike under these circumstances? You know, a president will often have a cadre of lawyers to advise him or her. The lawyers say, Madam President, we'll get you a memo in 2 months. That's not going to be enough in that situation. If there were a drone strike, civilians were killed, that theoretically could be subject to some sort of prosecution as murder. I think that might be the kind of place in which the court would properly recognize some kind of immunity. But that is, of course, nothing like what we've got here. I sort of take the former official's brief discussing the vesting clause to talk about the kind of the nature of charges when they focus on, again, subverting the electoral process. At a minimum, there should be no type of immunity that covers that.
So are you saying it should be a case-by-case balancing in each case, whether there's immunity, or how does this work as a legal standard?
So we think that it should just be, as the district court held, a finding. There is a balancing under Fitzgerald, right? That's our view. You start with this question: what are the burdens against the presidency, and what are the interests to be furthered? The answer to that question under Fitzgerald, we think that the burdens that my friend talks about on the other side are overstated. I'm happy to just describe why. We think the interest in the public's interest in an ongoing criminal prosecution means that there should be an across-the-board rule that a former president is indeed subject to criminal prosecution. What I'm describing in response to Judge Child's questions is, in a particular case, might there be some extraordinary circumstance where a former president could invoke an immunity? Maybe. I don't think the court has to reach that there. I think the court could write an opinion that reserves and says, based on the nature of the allegations, which we take as true, there is no reason to recognize that here. And so I don't think it needs to be a case-by-case analysis, but I think the court can reserve that type of question to the extent it gives one pause about a president in future situations.
To that end, can you answer the question I posed earlier to your opposing counsel about, are we to look at the broader question that was dealt with by Judge Chutkan with respect to presidential immunity, absolute immunity for no criminal prosecution of official acts, versus looking at this indictment and accepting as true the allegations that it brought there, or both?
So we have a strong preference that the court adopts the former view and looks at the question in the way of, as the district court did, which is to say, based on questions of separation of powers, of constitutional text, history, precedent, is there in fact immunity for a former president? We think the answer to that is no, for of course all of the reasons we put in the brief, and I'm happy to sort of address here. Candidly, I think if the court gets to that second question, there are some hard questions about the nature of official acts. And frankly, as I think Judge Pan's hypothetical described, I mean, what kind of world are we living in if, as I understood my friend on the other side to say here, a president orders his SEAL team to assassinate a political rival and resigns, for example, before an impeachment? Not a criminal act. President sells a pardon, resigns, or is not impeached? Not a crime. I think that is extraordinarily frightening future, and that is the kind of, we're talking about a balancing and a weighing of the interests. I think that should weigh extraordinarily heavily in the court's consideration.
Let me ask you about the effect of Blasingame. What is it? How does it either bind us? How is it persuasive for us?
So I think it formally has no application at all, because of course, very early on in the opinion, the court says we're not dealing with any questions of immunity in the criminal context. I tend to agree with my friend on the other side that in many respects, it does reinforce the nature of the Fitzgerald civil outer perimeter standard. It says you don't look at intent or you don't look at purpose. Context plays a more important role than often the content of communications. I think that the significant change, of course, is the acknowledgement of the looking at a president, whether that president is acting in his or her role as office seeker or office holder. But again, to go back to my response to Judge Childs' question, although that would change the nature of whether certain things are or are not official acts in the indictment, we just think that's entirely the wrong paradigm to use. We think under Fitzgerald, in fact, that would be inconsistent with Fitzgerald's reasoning, and also just irreconcilable with the nature of how criminal law works. I mean, to say that we're not going to take account of motive or intent, there are plenty of acts that every day. I mean, for example, if I were to encourage someone not to testify at trial because I wanted to go on a hike with that person, it's not a crime. If I were to encourage someone not to go on a hike because their testimony at trial, encourage them to skip their trial testimony because their testimony was going to incriminate me, it's the same underlying act. And now when you map that on to the presidential context, you come up with some of the frightening hypotheticals where as long as something is plausibly official, even if it involves assassinating a prominent critic or a business rival, that would seem to then
In what case could that
be exempt
plausibly
potentially from criminal prosecution. We certainly wouldn't concede that if that's the world we need to live in. I think we would advance plenty of arguments below, but we really, but those arguments themselves would create satellite litigation that are an additional reason not to go down this route.
But looking and thinking about your answer about potentially not looking at motive and intent, when there is a criminal prosecution, that mens rea and that intent is part of the actual statute charged criminally.
Yes, precisely. And that's why it wouldn't make sense to then come in and use this non-motive intent. As I understand how Fitzgerald outer perimeter standard might work, it could say those types of official acts, official conduct, that is something from which the president is immune. You don't ever get to that second question of, well, did that person act then with mens rea? Can we prove it beyond a reasonable doubt? Because it is, at least under a theory where it's not available at trial, then there's no way to reach that conduct.
When we're looking at this indictment, though, back to Judge Henderson's question about the use of Blasingame, some of the acts are same or similar, and there was direct discussion of it in that opinion as determining whether it was office seeker versus office holder. So do we use Blasingame at least for that?
So if this court decides the case the way the district court did, then I don't think Blasingame has any role to play at all, because there is no question of whether, was this act official or were these sets of allegations official? The question is, based on a Fitzgerald analysis and history, precedent, et cetera, is there any quantum of immunity for a former president? We think the answer to that question is no. There's no reason, as the district court also found, to turn to the indictment and consider this outer perimeter, this civil outer perimeter standard.
How about if you don't decide it the way the district court did?
If you don't, I suppose a lot would.
On the Blasingame.
So there are a lot of different ways this court could not decide it that way. I think to pick up on my response to Judge Childs, we certainly stand by our view in the brief that some substantial number of allegations would fall outside of an outer perimeter, and that I think is enough to affirm. I think either parties are urging the court at that point to then send, of course, the case back to the district court. I think that then would create a series of challenging questions that I mentioned earlier. What are the evidentiary theories under which that evidence could potentially come in? But it would be our strong view, and we would want, if the court followed that route, which we urge the court not to make clear that immunity is an on-off switch, right? This is the immunity appeal. If the court says we affirm, we send it back, there's no immunity, then other things become evidentiary questions or questions really of jury instructions, in which any appeal is then an appeal from a final judgment, if any final judgment.
And the immunity defense is never lost.
Well, I don't think it's immunity at that point. I think this court will, in what I've just described, will have said there is no immunity. There may be some types of other challenges as evidence comes in at trial. But again, I think that would lead to this extraordinarily complicated litigation that is not the top line reason, but certainly among the reasons why the court should not go down that path.
Since President Trump concedes that a president can be criminally prosecuted under some circumstances, he says that that is true only if he is first impeached and convicted by Congress. Do you agree that this appeal largely boils down to whether he's correct in his interpretation of the impeachment judgment clause? That is, if he's correct that the impeachment judgment clause includes this impeachment first rule, then he wins. And if he's wrong, if we think the impeachment judgment clause does not contain an impeachment first rule, then he loses.
So I think that's basically right. I mean, the defendant's theory over the course of this litigation has evolved a bit. And I think now before this court, I understand the argument to be principally sort of the principal submission to be, as you've just described, this, what we call in our brief, the conditioned precedent argument, that there is only liability, criminal liability for a former president if that president has been impeached and convicted. And that is wrong for textual, structural, historical reasons, and a host of practical ones, one of which I'll start with, again, to just amplify the point. It would mean that if a former president engages in assassination, selling pardons, these kinds of things, and then isn't impeached and convicted, there is no accountability for that individual. And that is frightening. Now, to go back to some of the textual and historical and structural, my friend on the other side sort of suggests this is what the founders were talking about and this is what they were worried about. I think that's entirely an inaccurate representation of the founding era history. There's basically no discussion of the impeachment judgment clause, which I take the defendant's principled textual argument to be. What the impeachment judgment clause did was two things, as the district court described, right? It constrained the sanctions that Congress could place on an impeached and convicted officer, not only a president, any kind of officer, to removal or disqualification. And then it made clear that that impeachment did not impose some sort of preclusive bar on subsequent criminal prosecution. You would think that if there was this kind of impeachment first requirement, impeachment and conviction first, you might actually find something somewhere in the sources, the framing, the convention in Philadelphia, the ratification discussions, early history. There is nothing of that. We've cited certain things in our brief from James Wilson, from Edmund Pendleton, from Representative Dana that say this. Justice Story. I don't hear the defendant to offer anything other than, well, Hamilton. All that Hamilton was describing was the undisputed point here that a sitting president can't be subject to criminal prosecution until that sitting president is no longer in office, whether the removal from office is through impeachment and conviction or simply the end of the term. Now, a structural point as well that I just want to quickly make, the district court made this, which is if this rule were right, that would if the conditioned precedent rule were correct, it would pose significant separation of powers problem of its own. It would basically mean that the executive branch would only be able to prosecute someone if Congress had acted. And there are all sorts of reasons why, of course, Congress won't act. For one, they've never believed that it was required. And also, in certain instances, they may decide that they don't have jurisdiction. Many of the members of Congress seem to hold that view with respect to the defendant's second impeachment.
Okay.
Thank you very much.
Yes, go ahead.
Thank you, Your Honor. And in my limited time remaining, I just want to make 3 points to the court in response to the opposing counsel's argument there. One is that the opposing counsel used the phrase above the law, saying that an immunity doctrine for criminal immunity would place the president above the law. I would just direct the court's attention to what the Supreme Court said in Nixon against Fitzgerald in the context of civil immunity. They described the allegation that immunity sets the official above the law as, quote, rhetorically chilling but wholly unjustified. The U.S. Constitution, the separation of powers, the executive vesting clause, the impeachment judgment clause, these are the foundational and fundamental law of our country, and the president's immunity is determined on that. So that is more rhetoric than reality, is what the Supreme Court said in Nixon against Fitzgerald. I'd also point out that when it comes to the question of whether or not the indictment alleges solely official acts, the indictment does not allege that President Trump did anything wrong after he left office. So it focuses solely on acts that he took while he was in office. And that's a telling indication that we're dealing with official acts here. And then finally, I would address Judge Henderson's your question about the floodgates. And I tie that to what my opposing counsel said about a so-called frightening future. The frightening future that he alleges, where presidents are very, very seldom, if ever, prosecuted because they have to be impeached and convicted first, is the one we've lived under for the last 235 years. That's not a frightening future. That's our republic. What he is forecasting is a situation where the floodgates will be opened. We are in a situation where we have the prosecution of the chief political opponent who's winning in every poll. Presidential election upcoming next year and is being prosecuted by the administration that he's seeking to replace. That is the frightening future. That is tailor-made to launch cycles of recrimination that will shake our republic for the future.
If you have the impeachment judgment clause, as you indicate impeachment, then conviction, but then the president either resigns, is removed, and then later on is prosecuted for a different crime. Can that happen, or is there immunity there?
Not sure I understand the hypothetical. Could you say it again? I apologize.
Just indicating that if you're resting on that there must be impeachment and conviction, and it's for one set of crimes, but then later on the president either is removed from office or resigns, and later on there's a prosecution for something different. Is there immunity for that later crime?
Yes, I think that's the better reason. Obviously, it's not presented in this case because we have a close match between the conduct, the underlying conduct or transaction occurrence that's alleged in the articles of impeachment, of which there was an acquittal, right? Which is the strongest case for double jeoprody, and between the facts alleged in the indictment. But if there were like an unrelated prosecution,
because you just made a statement about he's only being prosecuted for crimes while in office. And so that's why I'm asking about leaving office and then thereafter being prosecuted for something different.
To be under the plain text of the Constitution, the best reading would be he has to be impeached and convicted for the thing that he subsequently prosecuted. So if he were impeached, convicted, and removed from office, and they charge him with another official act that was unrelated to the impeachment, I think that what Chief Justice Marshall says in Marbury would still govern. I think that's obviously it's not presented in this case. The court doesn't have to decide it, but that'd be my answer.
So I just want to confirm your position is if President Trump had been convicted after his impeachment trial on incitement of insurrection, if he'd been convicted, then this prosecution would be entirely proper.
Which I would say that if you were impeached and convicted for the same and similar conduct, then that would authorize a subsequent prosecution. Because we have many other issues with this prosecution.
Is that a yes?
So I do.
Because I think you said in your brief that impeachment for incitement of insurrection is based on the same or related conduct as that which is in the indictment.
Yes, I agree with that.
So if he had been convicted by the Senate, then this prosecution would be entirely proper, correct?
Well, I would not phrase it that way because there's lots of other problems with this prosecution that we've raised in extensive pleadings to the district court. He could be prosecuted.
Under the impeachment judgment clause, if he had been convicted by the Senate when he was impeached for incitement of insurrection on same or related conduct as what's in the indictment, then this prosecution would be properly brought.
There's a prosecution could be properly brought. This prosecution, which has tons of other problems. I just want to be very clear about that. I'm making any concession that this prosecution is.
All right, let me try one more time. Under your interpretation of the impeachment judgment clause, if President Trump had been convicted when he was previously impeached on same or related conduct as that which is in this indictment, the government could properly prosecute him for that same or related conduct. Yes or no?
Potentially, provided they qualified with all kinds of other legal doctrines that are violated in this case. So I admit that a prosecution.
I'm only asking you under your interpretation of the impeachment judgment clause, is that proper? Is that allowed?
And I stand on my prior answer. I think we're agreeing.
I understand there might be other reasons why you would challenge this prosecution. I'm saying based on your interpretation of the clause, this prosecution would be properly brought.
Again, I would not say this prosecution, be very clear about that.
But it's a prosecution based on same or related conduct.
this prosecution, which has many other issues related to it, what I would say is that the impeachment judgment clause authorizes the prosecution of a president who's been impeached and convicted by the Senate, which President Trump
All right,
has not.
make it a hypothetical. Say a president was impeached and convicted on a charge of incitement of insurrection that is under the same allegations as a criminal indictment. He's convicted. Then the government could bring a prosecution for the same or related conduct, correct?
Don't disagree with that.
Okay.
That's correctly.
And then that means that the conduct that's same or related, even if it's official, he could be prosecuted for it, correct?
You're convicted.
Correct. Okay, thank you.
But my question goes to after the fact, and the reason I say that, even though you're challenging that these actions are only occurring while president, the district court's decision was that there is no presidential immunity from prosecution for official acts. It doesn't put a time frame in there. And so that's why I'm going to beyond your investigation, your prosecution might not come until later, after the president has left office. So are you telling us that we are limited to a time frame in answering this question?
I think the time frame is set forth by Chief Justice Hurley against Madison when he says never examinable by the courts. So unless there is that one gatekeeping incident that has to occur, which is impeachment and conviction, the official acts, the court has no jurisdiction to review them under the separation of powers and the executive vesting clause.
But that also assumes that an impeachment proceeding occurred. If there is not one, because we discussed earlier that not all officials go through that process.
Absolutely.
That's a judgment call as to whether that process would even be brought.
I would say we have two arguments that reinforce each other. So if there's no impeachment ever and no conviction, then the official acts are immune, period. Now, further, the impeachment judgment clause incorporates a doctrine of double jeopardy that prohibits it, especially in the case of acquittal. So those are reinforcing doctrines that are set forth in the Constitution. If there are no further questions, we'd ask the court to reverse.
All right. Thank you.
So those are some very important points. I'm glad they clarified them. So I wonder if I don't know if they're doing any more or if that's it. So we'll just keep an eye on this for a minute. So some interesting things that were brought up. So as we heard, John Sauer, who is the lawyer for Trump, he specified that this indictment that they're looking at now is talking about acts which occurred while President Trump was president. And so those therefore fall within his official duties, which according to the Constitution and according to Article 14, this is where we're all kind of talking about, are they immune? Does he first have to be impeached in order to be prosecuted? And so this is where the argument kind of lies, is the impeachment required prior to a criminal prosecution? And so Trump's defense is arguing that yes. And the reason for this is if you don't have that safeguard in place, because impeachment was put in place to prevent a political persecution. So you have to have a 2/3 vote from Congress in order to impeach. And the reason for that is that if it were, so the example they use, a president was used the seals to assassinate a political rival. That is a crime. That is a crime. And Congress could easily impeach him for that. And so if a president does something as blatant as that, then Congress could say, yeah, that's a crime. And we're impeaching you on that one. No problem. And therefore, you can be criminally prosecuted afterwards. So to say, well, you're saying that the president has immunity, it doesn't mean that he can't be prosecuted. It just means that safeguard is put in place so that this type of situation can't happen, where he comes back and they're just prosecuting whatever. And this is coming back on. Let's see if they're saying anything more.
Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3190, United States of America versus Donald J. Trump. Mr. Sauer for the appellant, Mr. Van de Vender for the appellate.
Oh, Van de Vender. Okay, he's the one drinking.
Thank you, Your Honor, and may it please the court. John Sauer appearing on behalf of the appellant, President Donald J. Trump. Gag order in this case installs a single federal district judge as a filter for core political speech between a
This is
leading
on
presidential
Judge
candidate
Chutkan's gag
and
order.
virtually every American voter in the United States at the very height of a presidential campaign. The order is unprecedented, and it sets a terrible precedent for future restrictions on core political speech. The Supreme Court said in Republican Party of Minnesota against White that we have, quote, never allowed the government to prohibit candidates from communicating relevant information to voters. And it's not the role of the government to dictate what topics are appropriate or necessary to discuss in the context of a political campaign. The gag order does both of those things. Cases involving gag orders imposed on criminal defendants who are political candidates, the Brown and Ford decisions, have both given, in the words of Brown, the candidate, quote, absolute freedom, virtually unrestricted ability to comment on both the case in front of him and make public statements that relate to his campaign as it relates to the case. So this is a radical departure from the only cases that have considered this particular form of restriction, a restriction on a criminal defendant who is also campaigning for public office. And it does so in the context of a hotly contested campaign for the highest office in the United States of America. In addition, the gag order, another unprecedented break with jurisprudence, relies completely on an insupportable heckler's veto theory. The gag order does not say, hey, your statements are going to, poison the jury pool by communicating directly with the members of the jury pool. What you have here is a rationale that says this speech, the speech that is targeted by the gag order, might, there's no evidence of this, but it might someday inspire some random third party to engage in some action that might result in harassment or threats to witnesses. This is a quintessential heckler's veto, which the Supreme Court has not traditionally subjected to scrutiny, even very strict scrutiny, but said is just categorically unconstitutional. And the reasons for that, if you look at the heckler's veto cases, in virtually every case, the argument justifying the heckler's veto is we have an absolutely compelling reason to do this because the speech that we want to suppress is going to inspire rioting, violence, injury, death, whatever it is. And the Supreme Court has said again and again, you cannot do that. All the gag order cases relied on the government do not address this particular heckler's veto kind of rationale for criminalizing speech. And the Supreme Court has held us again and again that is not a permissible rationale to silence anyone. Those cases go back decades, and that government rationale goes back to at least the city of New York in the 1860s.
Would your position be any different if it were a year ago? If the timing were just a year ago, so we're much further removed from a political campaign, would your position be the same or different?
Certainly a year ago, we would still be in the midst of a political campaign. I believe President Trump.
When are we not in a political campaign?
Right, okay. I don't mean to fight the hypothetical, but if you're saying that it was made in
A year ago, if it was a year ago.
Right.
If it was last November.
At a time when he was not a presidential candidate, all the other rationales.
But certainly
that we have relied on.
still engaged in political speech.
Absolutely, core political speech.
So would your
still
position
apply.
be any different a year ago?
I think the gag order would still be unconstitutional.
Would
under these
your
conditions.
position be any different?
I don't see how it would.
Okay, so the fact that we have a campaign going on does not matter. What matters to you, and this is still political speech,
I think
which gets very high protection, no doubt.
I wouldn't put it that way. I think that the fact that the campaign, in other words, we have a whole
Just
series of
said your
independent
position would be
reasons.
no different if it were a year ago.
Our position would be that it's still unconstitutional, but the campaign adds a additional and very powerful reason why it is
But
unconstitutional.
it's icing on the cake as far as you're concerned.
I
Your
think
position would be
I would-
exactly the same without a political campaign.
I would say it's the crown jewel of a series of at least 7
You need a
fundamental
crown
precepts.
jewel?
I mean, you think the outcome should be exactly the same, whether or not there's a political campaign underway?
Yes, I believe there are at least 7 independent First Amendment precepts that are violated by this gag order. Campaign speech is one of them. Heckler's veto is another one. So, for example, a year ago, we would still, if we had the same gag order, we would still be dealing with a categorically invalid Heckler's veto type theory. We would still be dealing with core political speech. Again, we would still be dealing with a situation where we have a restriction on criticism of public figures that violates the whole public figure doctrine. There'd be a whole series of reasons it would still be unconstitutional. However, one of the most powerful and compelling of those, I'm sorry, Your Honor.
So, Mr. Sauer, you point to the fact that your client is in the midst of a campaign, but I trust you agree that a prior restraint is, no matter to whom it would apply, is subject to the highest level of constitutional scrutiny. That's your argument.
Absolutely. Yes.
So, and I also trust that you agree that your client is not above the law that applies to all other Americans.
He's subject to the First Amendment in principally, but yes.
He's subject to the law that applies to everyone. He's not above the law.
We certainly haven't argued that, Your Honor.
Right. And so the district court found that when the defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. And we view that factual finding for clear error, right?
No, in a First Amendment case, I believe, as we cited in our standard review section under Houston against Hill, the court should engage in a plenary review of the record under de novo review. That is a mixed question of fact and law.
But for the findings about what happened in the world, we look at that for clear error, and then we look at the First Amendment implications de novo.
Looking at that particular finding, the court would have to look at it in light of the evidence in the record, which shows that that's all based on evidence that's 3 years old and is weighed against the fact that they have no evidence of any threats or harassment that have happened in this particular case, even arguably caused by the speech that's challenged here when the case has been pending for over 3 months and the defendant has made public comments about the case almost incessantly.
So the government's position, and this is just for purposes of the question, and I know you don't accept this, but the government's position is that that the district judge is not limited to looking only at the defendant's speech as it relates to this case, but the government identified a dynamic, not just exclusive to this case, whereby when the defendant has publicly attacked individuals, including but not limited to the facts of this case, those people are threatened and harassed. If we were satisfied, and I know you're not satisfied, but if we were satisfied that evidence supported that finding, what more would be needed in your view? What more would be needed to support the district court's order or an order?
Yeah, I would quote from Landmark Communications and its quotation from Pennencamp against Florida, which is that the standard that has to apply to a gag order applying or even a restriction on speech that relates to criminal proceedings is that the substantive evil that must be addressed must be extremely serious, and the degree of eminence must be extremely high, not remote or even probable, but imminently impending, and all that has to be proven by, quote, solidity of evidence. And when you have a situation, you use the phrase including but not limited to, because the fact that we have here is no evidence at all of threats or harassment in this particular case. All the evidence of threats and harassment go back 3 years ago to a totally different, political dynamic. And this points out another problem with this sort of heckler's veto third party argument, which is that they can't draw a causal line from any social media post, any threat or harassment, when we have wall-to-wall media coverage of this case. Every, talking heads on social media and on cable news and on network news are talking about it all the time. So
now
it's
just
entirely
focus on, and again, I know that you dispute this and you think that the record is inadequate. Were the record indisputably adequate to support a finding of a dynamic that when people are named, and as you point out, this is a defendant who has millions of social media followers. So when people are named on that social media, people are threatened and harassed. And also assume, for purposes of my question, that the threats don't rise to the level of a true threat that would be unprotected by the First Amendment. But we're talking about, in this case, I think we're trying to protect against threats that wouldn't be excluded from First Amendment protection. In that situation,
they're legal.
Non-public figures who are witnesses, non-public figures who are going to be witnesses. What about the interest of the
Except the
court
gag order does not
in a
limit
fair and impartial
that.
trial
It said
is
any witness.
insufficient to protect those witnesses from that dynamic which results predictably in harassment?
Let me say at least three things in response to that. First of all, a finding of a dynamic strikes me as a way to bake in speculation and hypothetical as a substitute for evidence. So if the district court said, I find a dynamic, I think that would be deeply problematic. It would have to be probed to see what the actual evidence was. Secondly, as to the question of sort of witnesses who are not public figures, there is no evidence of a single post about them in this particular case. So that piles hypothetical and speculation upon speculation. We've cited the Collins decision for saying you can't restrict speech based on secondary effects. That's like tertiary or quaternary effects. I don't even have an adjective for how many steps removed it is. And again, that's actually right there on JA 230, right there, the rationale of the district court judge is, well, we don't have any threats of harassment in this case, even though we've had wall-to-wall media coverage of it and wall-to-wall public statements going back for 3 months. But there might someday be threats of harassment to the only public figures that they've identified who are at the highest echelons of government.
I was actually focusing for a reason on non-public figures.
Yes.
And just to make your position, just to challenge you a little more.
For the case, that's a
The
crime.
order is
Prosecute them.
intentionally
That happens.
prophylactic. It's intentionally protective of against harms that have yet to occur. And in the distinctive context of protecting the integrity of a trial process, that can be a sufficient interest
The standard
for a
is
suppression of speech.
just prophylactic in the situation where the solidity of the evidence shows an imminently impending danger. We are nowhere near that in this particular case. And as I was saying about non-public figures, there's no evidence of any statement in this case that relates to any non-public figure. So again, you're piling, that would be, and in fact, the district court did that in this case.
Counsel, I think the concern is that it seems at times your position would be that the district court's hands are tied until we actually know there has already been harm to the integrity of the trial. For example, that a witness has been intimidated. And so I think the questions we're trying to get at, what evidence short of that, you certainly can't be saying that's what we need. What evidence short of that would the district court need before it could step in and enter an order like this?
Solidity of evidence that demonstrated an imminently impending threat. And again, that's Supreme Court case law.
But I think we're going back to
decades.
the legal standard. You mentioned the Fifth Circuit's decision in Brown.
Right.
And that court rejected the argument you're making today, which is essentially that the district court has no authority to regulate the speech of a criminal defendant unless it's entirely unprotected by the First Amendment. And what the Fifth Circuit said, drawing on Gentile and even the Landmark Communications case, is that the Supreme Court has drawn a distinction between speech restrictions on those who are participants in the trial and those who are strangers to it. I believe that's essentially a direct quote from Gentile. So what's your best argument that criminal defendants shouldn't be treated as within that category of participants in the trial?
If you look at Justice Rehnquist's opinion in Gentile, it's 12 pages.
Which was not a controlling opinion. The controlling opinion is Justice Rehnquist on the legal standard.
Exactly right. I'm talking about section 2 of that opinion is the controlling opinion of the court. Goes on for 12 pages about the specific, I mean, again and again and again, it's all about the special roles of attorneys. And it says attorneys are officers of the court. Attorneys can be subjected to particular restrictions that it directly contrasts with, for example, the rights of ordinary citizens or the common rights.
It also talks about participants. And there are a number of Supreme Court cases that distinguish participants in a criminal trial from those who are outsiders to the criminal trial. Would you at least agree that there is that language in Supreme Court cases?
There is some language, but I do
There
not
is
think
that
there's
language in Supreme Court cases, correct?
not language that would tie participants to the substantial likelihood of material prejudice standard. We do
I just want to
dispute
be a
that.
little more precise about this. So the quote from Gentile is there's a distinction between restrictions on the speech of those participating in the litigation and strangers to it. And it goes on to say of Shepard, the sort of canonical case about a trial court's obligations, quote, "We expressly contemplated that the speech of those participating before the courts could be limited." You mentioned Landmark. It's that concerned a sanction on the press. And footnote 9 of that opinion says, if this was limited to those who participated in the proceedings, it might well save the statute. And our job here is to read these Supreme Court cases, and it seems like they're drawing a very clear line of participants and non.
I don't hear anything or see anything in any of that language that says, therefore, you're subject to the substantial likelihood of material prejudice test. And we do dispute that. But even if that test applies, you would have to have much, much more evidence. Keep in mind that, Justice Kennedy's plurality opinion in Gentile emphasizes that the whole point of the substantial likelihood of material prejudice test was to approximate the clear and present danger test that we say applies. And he says the difference between those is likely mere semantics. Whatever that standard means, it is an exacting standard that is not even plausibly satisfied.
But if there is a different standard for participants as opposed to outsiders, if there is, this is my question to you, if there is a different standard for participants than there is for outsiders, so please take that premise, there has to be something different from clear and present danger, because then there would be no different standard for participants. So if we read these cases to mean what they say, there is a different standard for participants than outsiders to the proceeding. Do you have an argument as to what that standard should be other than clear and present danger? I'm simply, this is sort of like your plan B, if you have it. If there's a different standard, what should it be?
No one that I'm aware of has cited any case law that specifically addresses that question.
That's why I'm asking you.
Yeah, which is, to my mind, that's a powerful reason to adopt the clear and present danger standard. In other words, we say clear and present danger, they say substantial likelihood of material prejudice. No case at all adopts some intermediate standard between those two.
Well, you just told me substantial likelihood is very close.
And that's why there's nothing in between them, right? We
Okay,
say
so
they're
then
basically the same.
substantial likelihood may be close enough to clear and present danger.
If it's interpreted as we think it should be interpreted in light of
You
those
haven't
four
told
justice
us how it should be interpreted different from clear and present. If I'm going to say this again, the answer is not clear and present with different labels. If there's something less than clear and present, otherwise there's no differentiation between participants and outsiders. So if there is something less than clear and present danger, how would you articulate it? I am ready to write.
The two standards approximate each other, and I'm not aware of any case adopting anything in between.
You don't
those
have
two.
a standard
Yeah,
to offer the
correct,
court.
correct. Our position is the clear and present danger standard.
Full stop, and you have, if that is not what we adopt, then you have no other argument for us.
I don't have, I would have to invent a standard.
No, I'm asking, well, sometimes that's what the law requires.
Yeah, but-
So if we need to come up with something that still treats participants different from outsiders, and if outsiders get clear and present, that necessarily means participants get something less. That's what this case is about. And you say, the district court here applied the substantial likelihood test. So you've got nothing in between to offer us.
I would say clear and present danger is the standard that applies. If the court applies substantial likelihood of material prejudice, it ought to take count of the effect that that approximates the clear and present danger test. And the showing that was made in the district court here comes nowhere near satisfying either of those tests.
Okay. And well, we'll give you whatever time, we'll let you know. When there's, in your definition or application of clear and present danger, and that's an incredibly strict test, is there any limitation on a participant's speech? What does it capture that is not already outlawed by 1512 or something else? What speech would be captured that isn't already illegal in your mind? Can you give an example of some speech that would be covered by your clear and present danger test that isn't, in fact, unlawful form of threats, harassments?
Well, I mean, the notion of harassment, as we said in the Popa decision, raises the problem that some of the quote harassment may actually be First Amendment protected speech. So I don't think that would be it. Are there cases that would address speech that is not criminal, right? In other words, you say 1512 speech.
Can you give me an example of some speech that is covered by your test that isn't already covered by the criminal law?
I can't think of a hypothetical as I stand here.
So really your point then is that there can be no limitation on speech because his release conditions already forbid him to violate the law.
The conditions of release.
Forbid him to violate the law.
That is correct.
You can't give me an example of speech that could be regulated that doesn't violate the law.
I'm thinking of all the social media posts, for example,
Yeah.
that are.
You can make one up. It doesn't, I'm asking you to make something up here, not really refer to something that happened. I'm not asking you to say that.
I have trouble. I cannot think of a hypothetical that would not be a violation of the law.
Right, so
because we're dealing with the heckler's veto scenario.
So no, because then that means, I'm just trying to make sure I understand, and it may be right. We're dealing with political speech here, but your position is that at least when a participant in trial is engaged in political speech, there can be no limitation imposed to protect the administration of justice in the criminal proceeding.
No, that's
other
not,
than the pre-existing prohibition against violating the law.
no, that is
Okay, you just
not
couldn't
our
give me an
position.
example.
I've been asked for a hypothetical with no evidence at all to show how there might be some daylight between those two standards. And I frankly am thinking of all the social media posts at issue in this case and whatever else, whatever daylight there may be between those, these don't satisfy.
Well, this is a test that you've proposed, and so I'm trying to see if you have a conception of how it works that would allow a court to still protect the criminal proceeding beyond its prohibition on violating the law. And this is your test. And so it seems incumbent upon you to be able to explain to me what a court could do to protect the integrity of criminal proceedings that isn't already covered by a don't violate the law. Don't violate the criminal law.
Under Nebraska Press Association, the heavy burden of demonstrating, quote.
That's not, this is oral argument,
Yeah.
and you're here challenging an order and asking us to adopt a legal test. I mean, what's been crystal clear from the Supreme Court is they've even said many times recently, clear and present danger isn't a mechanical formulation. It's meant to be a balancing test, a test that balances the interests in speech, which you have explained are very high, and the interests in protecting the integrity of the criminal process and the criminal proceeding, which is also a weighty constitutional interest. And so the reason I'm asking this question is to see if there's any balance, which is what the Supreme Court tells us to do, in the test that you propose. And so tell me how it balances if you can't give me anything other than a criminal law violation that would satisfy your test.
The phrase I believe that the Fifth Circuit used in Brown, a case heavily relied on the government, is absolute freedom. In the context of a
Okay, so there is no balance.
criminal speech, obviously, is subject to the restrictions.
Then
But
that's,
core
okay, so
political speech, that is core political speech, that's part of campaign speech, that
I don't
raises
know
the
that
heckler's
I
veto
think
problem.
that kind of labeling it core political speech begs the question of whether it is in fact political speech, or whether it is political speech aimed at derailing or corrupting the criminal justice process. You can't simply label it that and conclude your balancing test that way. We have to balance.
Well, I think in the balance, the court should consider the fact that the issues at stake in the appeal are just absolutely inextricably, and in the gag order itself, not just the appeal, inextricably entwined with the issues that are being publicly debated in the context of the
Counsel, you
ongoing
mentioned
campaign.
Brown a few times and the fact that that order was lifted in the run-up to the election.
Mhm.
What actually happened in that case is that the district court, at the outset, without any evidence, the only evidence was that there was general press attention to the case, and it sua sponte entered a very broad gag order. It then lifted that in the run-up to the election, but the defendants then started sharing recordings relevant to the case with the press, and the court stepped in and reimposed a limited form of the gag order. So my question is, why isn't the analogy here to that second narrower gag order that the court entered in Brown? That's what happened here. The district court didn't act rashly. It waited. Back in August, it gave clear warnings to the parties not to make the type of statements that were at issue. That trend continued. And now we have an order that's targeted at the exact types of statements that have been occurring. So that's my question. In Brown, they did reimpose an order during the election.
Yeah, looking at the facts of Brown, I believe it was other defendants, not the political candidate, who started leaking, it was confidential transcripts of jury materials and giving interviews about them. The court reissued a gag order that basically said, don't release stuff you're getting through discovery that is otherwise confidential, which is totally different than the gag order we have here, right? This is not a situation, we haven't disputed in this case that a district court could say, hey, you've gotten access to materials only through discovery. This is like the Seattle Times situation, and therefore you can't release those to the public. So then Brown goes on to say that he was given complete latitude to actually defend himself in the political arena, which is the critical issue, or which is one of the many critical issues at stake in this appeal. And it was given, and it says it may well be the case that for the benefit of the electorate as well as himself, he has absolute freedom to discuss it. And keep in mind, the electorate there was people voting for a Louisiana insurance commissioner.
Yeah.
Here we're talking about every voter in the United States of America.
I do want to
hearing
get to
from-
questions about the scope of what he's able to say, but just briefly back to the evidence. You're certainly correct that most of the threats at issue, this pattern of statements followed by threats, is from 2020. But I think the link might be, and I wonder what your response is, that that was all about the same subject matter of this case. So essentially what the district court is finding is we have a past pattern. When the defendant speaks on this subject, threats follow. And now he's making similar statements again. We're months out from the trial. This is predictably going to intensify as well as the threats. And so why isn't the district court justified in taking a proactive measure, not waiting for more and more threats to actually occur and stepping in to protect the integrity of the trial?
There's an evidentiary burden here. The evidence, actually, it isn't just that there's no evidence now, it's that the evidence we have now completely counteracts that inference, because it is undisputed that President Trump has been posting about this case almost incessantly since the day it was filed, and they haven't come forward with a single threat that's even arguably inspired by any of his social media posts. The only threat they talk about in their brief is from the Schrei decision, from the Schrei case from the Southern District of Texas. I strongly invite the court.
Well, counsel, and a death threat to the
That
district
is the
court
one I'm
judge
talking
in
about.
this case.
Right, Abigail Jo
Right.
Schrei, that is the August 5th telephone call.
And that's a
If you
crime.
It's Southern District of Texas.
The day after he said,
prosecute
if you
her.
come after me, I'm coming after you, that threat issued.
I strongly encourage the court to pull both the probable cause statement and the detention order from that case, where there's evidence that that particular threatener, there's no evidence of any reading of social media. That particular threatener is a unemployed, mentally unstable, heavy alcoholic who sits on her couch drinking beer all day, according to her father, never leaves the apartment, watches the news, not reads things on social media, watches the news on TV, gets
Judge
angry
said
about
death
it, and makes
threats.
angry
That's
threatening
not
calls.
the
without
I'm
fault
sorry,
leaving her
anybody
counsel,
other
this
than
might
the
have been
person
partly my
offering the
fault,
death
but I want to go back. Imagine all we had was the 2020 pattern. That evidence is very specific. It's about when the president speaks on this issue, events around January 6th, and that there are very specific threats that people receive. And again, that was a time where, as you're saying, the atmosphere was very tense. As this trial approaches, the atmosphere is going to be increasingly tense.
Loud
Why
and
does
clear.
the district
She's
court
any
have to
better.
wait and see and wait for the threats to come rather than taking a reasonable action in advance?
Again, the standard is imminently impending, solidity of evidence. We have an inference from stuff that happened 3 years ago, countervailed, contradicted by the evidence we actually have here, which is wall to wall. I mean, they are saying, oh, it's an imminent threat
Let me
that
ask
someone
you
could be harassed. And
this-
it
Let me
hasn't
ask
happened.
you, Mr. Sauer, the conditions of release in this case prohibit your client from communicating about the facts of the case with any individual known to the defendant to be a witness, except through counsel or in the presence of counsel. Your client signed those conditions of release. Counsel before the district court was quite clear that that was not being challenged. How, under your analysis, would those conditions of release not be invalid? Are you taking a position that those conditions of release violate the First Amendment?
No, we have never challenged the conditions of release, and the president has complied with them.
And
There's
how
no-
under your analysis would they not be unconstitutional?
Well, a violation of that condition of release may be the response to Judge
Is
Miller's
this any
question
better?
earlier
I was
about
wondering about
when
that.
that would be something, for example,
enough?
that might not be criminal, but would be a clear and present danger to the
That
administration of
would,
justice.
I don't want mites. I'm really trying to understand your legal test.
I-
If he were to pick up the phone and call someone that is known to him to be a witness, prospective witness in this case, and speak with that person without counsel present.
I'm going to try something. I'm going to mute
Would,
something really
could-
quick.
would
Let me
that-
know.
That would
you still do
violate
the court case.
the
Okay, ready?
restriction
1, 2,
undoubtedly.
3.
Would the First Amendment protect that communication under your test?
We have not contended that.
It's not what I am asking. I'm asking you to apply the test
Could
that
you
you
still hear the
propose us.
court case?
We have to write a test that can be applied, and we have to know how it's going to be applied. So I'm asking your position, your legal position. would that phone call be protected by the First Amendment or not?
Is it a phone call where what said is Happy Thanksgiving, or is it a phone call where it
I'm
said,
not telling
"I
you
want you to
why,
testify,
because
sir"?
the order, the pre-release, the release restriction doesn't care about the content.
Yeah, I
So
don't,
he picks up the phone and calls a witness
Okay.
in direct violation of the terms of release.
we do not contend that would,
I'm
we
not
tried to buy the First
contending you.
Amendment. It
Okay,
would
so
not.
that would
people
not
testify-
violate the First Amendment. That is
That-
allowed under the First Amendment.
Yes, that's completely consistent with the
Okay.
positions we've taken in this case.
And now if the next hypothetical is he gets on the phone and he says, X, Ms. X, you've always been someone, courage, backbone, a loyalist, a patriot. And you know, loyalists and patriots don't talk to prosecutors in my case, and hangs up. Okay, if he said that,
I think that would be a clear violation of the terms of
yes,
release,
okay.
also
What if
unprotected
he
by the First
instead
Amendment.
gets on a stage somewhere or on social media and says that exact same thing? Ms. X, a public figure, is being bothered by the prosecutor. But people who are loyal, honest patriots don't talk to the government.
He hasn't said that, and it is a
Please answer
mischaracterization to say
the
that.
question. I'm not suggesting he has said that. This is to be clear for the record, this is a hypothetical question. Does punishing that conduct, because he's not speaking directly to the witness, he's doing this on social media or at a town hall or a news interview.
So
He
remember,
says that.
the appeals judges have to go through all these
Does it
hypotheticals.
violate the First Amendment to say that's
Hey guys, can you hear me? Am I back? Let's check everything. Let me know if you can hear me and see me. Looks like everything is going on my end. Okay, I'm gonna get this back up again. So the internet went down. I'm not sure why, what happened, but I want to make sure. Yay! Okay, Dorothy, you can see me. Hooray! All right. So I had this paused at kind of pretty much, I think, where we stopped. So it should be, we'll just pick it right back up from where we were before. So hopefully everybody's, I don't know if it was just because of the storm, what's going on, but I don't know, it's crazy. So I'm just going to make sure, can everyone see me? But we're here. So looks like, I don't know if everyone left or what, but hopefully they'll come back. We'll see. We're just going to keep playing this. So Dorothy, you can see me. It might just be you and me that can see this. But we'll keep going. Okay. Let's try this again.
No evidence on that particular case before the district judge. Apparently, it was relying on, sua sponte reviewing of media
Let me make sure.
reports,
Let me
when in fact,
know that you can see
the
this,
statements
hear this,
about the
all that
principal
good
law
stuff.
clerk in the pending New York civil trial were absolutely core political speech. It definitely violated the First Amendment.
I'm
So,
talking about in this case, though,
Yeah,
where
no-
there's an effort prophylactically to protect court staff. And my premise is, or my question for you is, when you say there's complete overlap, it seems that that's an easy case where there actually isn't overlap, that individuals who are working for the judge assigned to this case would be no topic in a campaign other than an effort to undermine this case qua case.
I mean, I think I would say a couple of things. That I think we're talking hypothetically. The president has never made a statement relating to this case about any court staffer that I'm aware of.
But the order, as you well know, and as you've challenged, the order applies to court staff.
With no evidence to support it. If that can't satisfy any.
That aspect of it. I appreciate that aspect of it, that you've made a point about whether there's evidence or not. But I'm talking about the claimed overlap between political speech and the speech that's restricted by the order. And I'm positing that there actually is speech restricted by the order that would not be campaign speech, but for this case. And surely you can see that.
I think the New York decision shows exactly the opposite.
We're not talking about those circumstances. If there were a staffer of the judge about whom it became clear that there was some political bias, nobody disputes that the defendant's team could and would file a motion with the judge to raise a concern about that and comment on how the judge ruled on that. But that's not where we are. We're in a situation of prophylaxis, and that's really what I'm asking you about. A prophylactic situation where nobody who works for the court, these are career people, nobody volunteered for this assignment, none of them have life tenure, they're just trying to do their jobs. Nothing about them would be campaign speech in the absence of a case.
But what we see in New York is that if you enter that prophylaxis now based on—
We're not in New York.
If you enter that prophylaxis now based on zero evidence, no evidence at all, no evidence of the political bias might be as of the court staffers, and no evidence of any statement about any court staffers. And if it later turns out that there's an extremely biased court staffer, we have a huge First Amendment problem. We have a prior restraint based on no evidence, which is what this is.
Let me ask you then in a different way. Let's say that kind of situation arose here and the order remains in place and is valid. So the defendant is in jeopardy of violating the order by tweeting about it. Nothing would prevent the legal team in that situation from filing an emergency motion with the court, coming up to the emergency panel of this court and saying, there's bias here. And presumably, once that's filed in the court, nothing would prevent the defendant from complaining about the way it's ruled on.
That flips the First Amendment on its head. The burden is on them to testify.
I'm just saying there is a protection there.
There would be potentially the additional run-in on emergency motions. Keep in mind what it's black letter law, what the Supreme Court said in Elrod against Burns, which is that denial of First Amendment freedoms, even for minimal periods of time, is black letter irreparable injury. So even injecting that delay, that procedural delay, keep in mind, we're talking about a prior restraint that is, I think everyone can, just based on no evidence at all. But in fact, if it were to become relevant, there could be compelling First Amendment interest in calling public attention to the alleged bias of the court staffer, which is what we see in New York, a gag order that is now staying.
There's no precedent that I'm aware of that requires evidence of tampering with witnesses before a prophylactic order can be put in place to protect tampering with witnesses. Am I wrong about that?
I think the case law says you have to have an imminently impending threat to the administration of justice.
About witnesses? Communicating with witnesses?
Yeah, but that's the general standard for all those. Now, oh, you mean for the defendant to directly communicate with a witness? That again, I think goes
Or
to
saying publicly threatening things about witnesses.
I think, what do you mean by threatening? Because the First Amendment has a clear test of
Something that falls short of true threat, because we wouldn't be here if that's the only thing that we're protecting against.
in the context of a political campaign, what's described as a threat here is core political speech. I cannot emphasize that enough. So the hypothetical is saying, well, what if he makes a threatening statement? What they've described as threats is actually, under the Supreme Court's jurisprudence, core political speech. It is rough and tumble, but it is hard-hitting in many situations, but it absolutely is core political speech. And all the examples they provided, it's directed at public figures from the highest echelons of government, former vice president, former attorney general, former chairman of the Joint Chiefs of Staff who used to command the entire United States military. And the argument is that it's going to influence their testimony. It's just not a compelling.
The release condition says defendant shall not communicate with witnesses. You keep talking about directly communicate. So is it your position that if he communicates through a social media post, hey, witness X, I know the prosecutor's bothering you, trying to get you to say bad things about me. Be a patriot. Don't act treasonously. Don't cooperate.
We have no social.
I am not. It is really, I'm sorry, but I really want an answer to your understanding of the release conditions. This is, for the record, a hypothetical question. It, to my knowledge, hasn't happened. Apparently, to your knowledge, hasn't happened. Not even saying it would happen. I want to understand how you, because you have said no First Amendment problem with the release condition. Okay? So I've asked you that question. Does that communication violate the release condition?
A social media post that is a direct communication to a witness could well violate it. We would have to know more about the context.
No, I've given you exactly the content of the communication. I don't know what more you want. I've given you the text. And so that's what comes into court. Is that a violation? That very well might be. So when you say indirect communication, because you keep saying direct communications as opposed to, I assume, indirect.
Well,
What indirect communications with witnesses are allowed?
If there's a hypothetical, for example, that was raised earlier, where he's at a town hall speaking to the entire American public, televised, and says something that's core political speech.
Okay,
to
if he
say,
says
oh,
that
that's a
exact
communication to
same
the
thing,
witness.
if he says the exact same thing, hey, I know witness X is out there, and that says exactly what I said.
What I would do is put that in the framework of the comments about Vice President Pence.
No.
So-
Don't put it in any other framework. Just tell me, does that violate the release conditions?
I want it, before I answer that question, I would like to make the point that the context may result in a different answer to that question. As you've described it, that could well be a violation of release conditions, but the context is absolutely critical. In many of these cases, look at the posts about Vice President Pence. They say, oh, look, he's commenting on Vice President Pence's testimony. What actually happened there is on August 1st, the indictment is released with a statement about too honest.
That's not my hypothetical. My hypothetical was quite clearly about cooperating with the prosecutor or not.
I think the real world course of communication relating to Vice President Pence illustrates my response that we must know the context.
What more context do you want from my hypothetical?
Well, for example, look at Vice President Pence.
No. Tell me what fact you need to know from my hypothetical.
What if that is?
Hey, witness X, I know you're listening. And then talks about prosecutors been bothering you. Anyone who's faithful, loyal, won't work with this prosecutor who's out to get me, doing so, lying, that would be like, almost like treason.
What if witness X is just?
I am,
leaked to-
so wait, so what more facts do you need?
Well, what if that is a fair response to something that witness X has said in the
I'm
political
asking you
arena?
whether it's, I'm not asking whether fair or not. That, I don't see anything in the release condition that says only unfair communications are prohibited. Is that a communication to a witness?
And I think I've already stated that it could well be.
Could well be, it is,
Could
or
well
is,
be. Well, again,
there's another fact you need to know to tell me that it is a communication with a witness. What would that fact be?
Well, if, for example, if it is a statement being made in the political arena that is not
It's a
directed to the
political
witness, but
arena.
directed to the public as a whole.
It's a political, I've just said, it's a political arena. It's either a social media post or he's standing in the town hall. So it's in a political arena.
And I think my answer is, I just don't know how to answer it differently. It could well violate it. It seems like the way you've described it, that would be a violation.
Violation of the.
But with the caveat that
So
there could
some
be
of-
additional facts that would lead to a different conclusion.
So,
And this is the-
so just because I've been struggling to try to understand what your test captures, right? And so it's, in addition to criminal law violations, it captures his messaging to at least known prospective witnesses about cooperation.
It could well do so. Again, it would depend on.
And so the
context.
First Amendment would allow, you'd have arguments on both sides, but the First Amendment, if the district court concluded factually that that were a communication with a witness without counsel present, then that First Amendment would allow punishment of that.
If there was evidence supporting that finding, and the finding
course.
was made that there was a violation.
The
of
evidence is
conditions of
going to be
release,
the
yeah,
tweet or the recording of the town hall meeting, whatever.
never disputed that. We
Okay.
never disputed that if there is now what I resist doing is trying to try this case based on hypotheticals when the standard is, let's look at the evidence. Because the evidence we have.
No one's
something-
trying a case based on hypotheticals. We are testing the legal rule that you wish us to adopt, because again, as the Supreme Court has, I know you have embraced the Nebraska test and made very good arguments about that and about the importance of political speech here. You've made very, very important points about that, but the Supreme Court has said that's not a technical metric to be applied, clear and present danger. It bespeaks a balancing test. And so what I've been struggling with this argument is to understand what in your test balances the legitimate, constitutionally important values of protecting the criminal trial process. And so it sounds like, at least if he's talking about prospective witnesses, there may be some room there between what would be illegal and what could constitutionally be proscribed through an order of the court.
I think I agree with that, as you framed it. And I would say two further things. One is I direct the court's attention to the heckler's veto cases. Heckler's veto rationales have uniformly been treated as basically categorically invalid. So whatever room there is there when dealing with the heckler's veto rationale is vanishingly small.
I know, but there's, there's also another rule in the law that people are, can be assumed to intend the known and probable consequences of their actions. That's a pretty settled rule of law as well. And a district court trying to protect the integrity and fair administration of the criminal process, could they consider that well-established rule?
Not under heckler's veto theory.
They're not doing it under a theory. What I'm saying is, could they, if hypothetically, this hasn't happened, this is a hypothetical, a statement were made by another criminal defendant who's running for some low-level office and made a statement that ended up causing harm to that, inspired some third person to engage in harm. And it were shown, be a hard showing to make, that the speaker was aware that there were known and probable consequences of this violent action ensuing from his, you're already shaking your head no. of his
My
speech.
answer is going to be no. I think that
So
would
that rule
violate
just doesn't
decades of
apply.
Supreme Court's case law, heckler's veto. Because
That rule
the
just
notion that,
doesn't apply
oh,
here.
you knew this was going to happen could be made in every single heckler's veto case.
Uh-huh.
Oh, you
But
knew
we're
when you gave this
balancing
speech
against,
you knew when you marched through Illinois dressed in your crazy
you're
outfits.
balancing, those cases didn't involve balancing against another constitutional interest in preserving the integrity of the criminal justice process. And so that's where my question is coming from. Yeah, those cases, but they didn't involve the balance. You've agreed, you agree we have to balance, right? The Supreme Court has said this is even your clear and present danger test is a balancing test. Do you agree with that?
I don't view strict scrutiny as a balancing test. We've argued that it's
Okay, the
either per
Supreme
se
Court has
invalid
said,
or
the Supreme Court has said in straight up terms that clear and present danger is in fact not a technical rubric, but in fact is simply a balancing test. That's what the Supreme Court has said. So we're bound by it, whether you agree or not. But I assume you agree there's a balance here that doesn't exist in the normal First Amendment context.
I don't dispute that there is a balancing to be
Right.
done, but to me, the term balance suggests a kind of looseness in the legal standards that apply, and we disagree with that categorically. There's the strictest of standards.
Strict scrutiny is a balancing test.
I
Right.
don't describe it as such,
Right.
and maybe that's why there's miscommunication.
Right, you're balancing
understand.
competing, and the Supreme Court has told us, whether you agree or not, but so I'm hoping you will agree, because the Supreme Court precedent is quite clear, that whether you formulate as clear and present danger or otherwise, the First Amendment area, we're in a balancing test here. And so we are balancing, and particularly in these cases involving criminal process and free speech. They've said time and again, it's a balancing test. And now that doesn't mean it's 50-50, right? Your position, of course, is that this isn't a 50-50 balancing. There's already a lot of weight on the First Amendment side, right?
So
Right?
understood. I don't
Right.
dispute the court's
Right.
use
So
of the
there's
phrase balancing at all, but with the caveat that we have argued that under the heckler's veto standard, it is per se invalid. All the cases they've relied on are not heckler's veto cases. And that is really what the Supreme Court says, because if you engage in any scrutiny at all in a heckler's veto context,
So
you're
if
going
we
to end up
had-
being able to shut down every speaker who ever speaks. And that's,
We had a different, if we had different, first of all, I'm not shutting down everyone who speaks. This is only no one's shutting down, and this is only affecting speech temporarily during a criminal trial process by someone who has been indicted as a felon. So that's a different category first. So no one here is threatening the First Amendment broadly. But secondly, if we had hypothetically a completely different criminal defendant who is running for, say, we'll say a statewide office, pretty important, statewide office. And this person, hypothetical facts not before us, engages in political speech decrying the process, the criminal process, insulting, berating, and calling terrible names of the prosecutor and the prosecutor's family, and starts posting the address where they live. And every time this campaigner does that, someone in his audience goes and tries to execute violence against the prosecutor or family members. That is not this case. But if that happened, if there were a repeated pattern of it happening, how would that fit into your balance?
I think the first half of your hypothetical is exactly like the case against Congressman Ford, where he was allowed to say the prosecution against me is racist, I'm being persecuted by the Reagan
The
administration.
first half, but of course,
so
the
forth.
second half was really important. And
Right,
that is
right. And when
that
it
there's
comes to,
a
like, if you're
repeated,
saying, oh,
there's a repeated pattern. And so I'm not asking for a case citation here. You've done an excellent job in your briefing to give us really important, relevant cases. What I'm asking for is, in that hypothetical, if there's a repeated pattern in the balancing test, could the district court factor that repeated pattern of conduct by third parties responding to speech?
Not if that pattern was 3 years old and the evidence.
That's not my
actually in the
question.
case.
No.
I mean, again,
If it's right, if it's immediate,
in other words, if you
an
have a
ongoing
criminal
pattern,
defendant who's
this was-
posting street addresses, home addresses of, whoever it is, witnesses and trial participants, and there's a repeated pattern
or their family
of acts
members.
of violence against them, I'd have to know more. I'm qualifying what I say with saying I'd have to know more about the facts of that case, but I could certainly see a situation where that would be justified. I'm not saying that it can never, ever be justified, with the exception that the
That would be-
heckler's veto rationale.
Well, that is a heckler's veto. It's how third parties respond to the speech. It is definitely, I think, what you are calling a heckler's veto, but it is also, I'm combining that with either intent or at least knowledge or recklessness on the part of the political speaker as to the entirely foreseeable and repeated pattern of consequences from that speech.
Yeah, I think my response to that is that the so-called, state of mind of the speaker is irrelevant in the heckler's veto context.
Right.
And we have no evidence of an improper state of mind here. We have an argument from the district judge. And I do keep returning to the facts of this case because the facts here don't come anywhere close to justifying this gag order. And I don't know, I know I've gone way over my time.
No, that's okay. I think as long as we have questions, if you don't mind, if you're
Go
okay.
ahead.
I want to make sure we hear from you on the vagueness argument. So it's a little bit separate from what we've been talking about so far. But I think the question to you, just to step back, the district court is concerned about witness intimidation. It also worked hard to give some leeway to the First Amendment values. And so the order it entered is narrower than what the government wanted. There's a significant carve out. And it certainly gives rise to close edge cases. But I think the question to you is, with the two orders, with all the examples in the transcript, what is something that you're genuinely unsure whether Mr. Trump can say under this order? What's your sort of best concrete example of that?
Half of the social media posts on the record. I mean, you go through them, you're like, is this general or is it targeting? I mean, from the perspective of a lawyer who has to counsel clients, you're steering, because it's so vague, you're steering straight towards the shoals of chilling more speech that is intended to be.
So I appreciate that general point. The district court took a lot of care in an extensive hearing to go through a lot of examples and references those in the order denying the stay. So what I would love to hear is if there's one, particular example of those posts that you don't think has been resolved.
Yeah, I think there's, for example, there's one social media post in the record that doesn't mention the special counsel by name, but refers to the Department of Injustice being run by crooked Joe Biden, who are, railroading me. I don't remember the exact words of it, but railroading me for political reasons. Is that targeting the special counsel, or is that a general
Seems to me that's exactly what the district court was saying was allowed. Statements about the Department of Justice and President Biden. That's sort of the literal words of the carve out. So I would think, and maybe that's a question for the government, but I'm pretty sure that's common ground that that's allowed.
I think that I would refer the court to the actual social media post. When I read that, I'm like, what would I tell a client? Can you do this or can't you do this? That's the chilling effect. And I would emphasize to the court the standard in Gentile. Gentile, the governing opinion on the vagueness issue is Section 3 of Justice Kennedy's opinion. That's the opinion of the court. What does it hold? It holds that the State Bar of Nevada had a rule that says you can make a general denial of your client's guilt, but you cannot elaborate. And Justice Kennedy says this is unconstitutionally vague. Its contours are unclear, and a lawyer cannot know when you go from the safe harbor of the general to the forbidden sea of the elaborated. And here we have
Counsel, I appreciate that.
Exactly on point.
I appreciate that argument. I think one big distinction is that in Gentile, it was a generally applicable rule. Here, we have an order that's informed by the transcript and all of the examples that were given. And it does seem like the core of what's allowed and what's not is fairly clear. So just for example, I think this is page 201 of the appendix. Your co-counsel says that Mr. Trump should be able to say a joint chief of staff should not engage in that kind of conduct, referring to Milley. And the court says, yes, he's allowed to make that type of statement. What he can't do is go on and say that type of conduct should be punishable by death. And so it's not sort of a completely abstract distinction, is it? It's whether there's a suggestion of a threat.
I think what you said powerfully illustrates the vagueness, because if their position is there's two statements about General Milley, one is okay and the other is not okay. I don't know how, as an attorney who has to counsel a client to comply with the law, how you would say, oh, that first one is not targeting him. It's critical of him. The dictionary definition of target that we cited, that would be targeting. And the argument is, well, we're not going to count that one because the First Amendment interests are obviously clear.
See what my concern is, though? It's not about the abstract meaning. We're not asking whether an ordinary person in the public can understand what targeting means. We're asking whether the parties who are all represented at this hearing can understand. And so we have that statement, right? And then the government makes similar examples on page 40 of their brief that allowed, not allowed. And I'm just trying to ask which ones.
I think I would
understand
cite,
you're
I
doing
would
your-
cite to the court to address this, the Granted standard. The Granted standard is you can have a situation where there'd be ad hoc or subjective application of the standard. So we have an order that says don't target, right? Don't target prosecutors, witnesses, court staff. And then the prosecution comes in and says, actually, it'd be okay to make a public statement criticizing someone who's a potential witness they contend. And that wouldn't be targeting. At that point, from the defense perspective, it's like, what does target mean? We have an answer to that. Go ahead.
I appreciate that,
Yeah.
that concern about targeting. So is it clearer or less clear if the order were to say that what's prohibited is comment on any reasonably foreseeable witness because of the witness's potential participation in the trial? And let me just give you a little bit of context of my thinking on that, which is there are a lot of people who are out in the public and with whom the defendant has a history, and he has reason apart from the trial that he might want to comment on them. There is also a whole category of witnesses with whom there is no, who are not public figures, and where the reason that he might be tempted to comment on them in the campaign is because they're potential witnesses. And that's really at the core of the interest in an impartial trial. So does that add clarity?
But also,
to
if
say
you
that
limit
can
his
only
ability
make
to
comments
comment on the witnesses that
on
are
potential witnesses, but not
anything to do with his
because
campaign,
of
it limits his
their
political
potential role as witnesses.
speech.
I think sort of a standard, I think because of what sort of wrap into that standard subjective motivation of the speaker, and I think that would be, an equally bad, it's a different vagueness problem, but it's equally bad. Using the word comment instead of target, that might be clearer. I'd have to look that up in the dictionary to have a clear answer, which is what we did here for target.
What's
it would
doing the
trade-
work of targeting is the because of, which I think is narrower than targeting, because it's both targeting and then linking it to the interest, which is the trial and protecting the trial. And it also, I think, organically distinguishes between the public figures there would be more reasons that they would be fair game, and the non-public figures who also at the same time might be more vulnerable.
If there were an order that used because of, then I think that would be naturally interpreted to turn the violation on the subjective motivation and making the post. I think that would be
I'm not so
all
sure.
kinds of grain-head problems.
I'm not so sure, although I think if I were in your position, I would embrace an intent standard, but I don't see this as an intent standard. I see this as as more of a nexus, and it would have to be assessed.
Again, I think that would trade one vagueness problem for another.
And be worse or less unclear?
I don't know. I think they both seem fatal, so I think it's equally bad.
Equally bad, okay.
If the day after the indictment, defendants send out on social media, quote, "If you go after me, I'm coming after you." Can you say that's protected speech?
Absolutely.
If he had said that right outside the courthouse, to a phalanx of cameras, so he's speaking to the public, same answer?
I think so.
Yes,
He
because he was
Posts it with a
could
picture of
mean
the
if
district
you
court judge in the
politically go
corner.
after me, I'm politically going
Again,
Same
we'd be
after
getting
you.
into,
It can be interpreted in many different ways.
I'd have to
It
know the
should fall under
context
free
of that.
speech.
I've given you the context. It's the same identical social media post, but adds a picture of the district court judge in the corner.
I'd have to look at case law. That would be more problematic for sure.
Why?
Well, I think because then in the context of the state, at least the context that you've added in the hypothetical, that again is not present in the courthouse here, there would be a situation where an argument can be made that that's some kind of threat to the district judge, which if it rose to the level of true threats, and I haven't read the case law, I cannot make a legal determination as I stand at the podium, but if it rose to that level, that would definitely not be protected by the First Amendment. Yet a similar threat in one of the
So
cases
adding,
they cite,
so
the
the same
Manafort decision.
words. There are words that can be said that adding a picture will take them outside the
Yeah,
First Amendment.
and again,
in
I
your
don't
view.
concede that would, but I'm saying it's getting closer. For example, in the Manafort decision, there was a posting of a picture of the district judge with crosshairs, I think,
Indeed.
next to the district judge's head. There, you're outside
Right.
the First Amendment almost certainly.
We
I would
don't have to
imagine
wait.
that would be
Almost
a true
certainly?
threat. I
You
mean,
just
again,
say certainly?
I haven't read the true threats case law, but I bet that statements like that would qualify as through threats.
So this really gets back to the one thing that I'm finding really elusive in your presentation. I understand that you think the ordinary First Amendment prior restraint, strict scrutiny standard applies, but even taking that as the correct position, in contradistinction to Gentile, which you would reject, I don't hear you giving any weight at all to the interest in a fair trial. And am I right that you don't? That simply because the defendant is a presidential candidate and he wants to speak on anything he wants to speak, and he basically indiscriminately wants to post on social media, that there can be no restraint of his speech, because any restraint, no matter how tight a nexus to protecting a fair trial, is overcome by his campaign interests?
I emphasize two things in response to that question. One is that the speech at issue and the criminal trial are deeply intertwined. And the other is the statement in the Brown decision that talks about absolute freedom, at least while the campaign is pending.
So your answer is there is no work that the interest in a fair trial can permissibly do
at the very least
in this situation that could meet the speech standard that you would apply.
I wouldn't put it that way. I would say the showing would have to be extraordinarily compelling at the very least. And again, I would quote the language in Landmark and Pennington.
And as I
talks about,
hear your answer, sorry to interrupt, but we've been going for quite a while. As I hear your answer, the compelling showing would have to show the harm had already occurred and that it was likely to repeat. You're not able to accept the notion that there could be a prophylactic, a showing based on some amount of prediction.
I disagree with that, because I think the standard that we cited in Landmark says imminently impending based on solidity of evidence. So that does say there could be a restriction that's entered before there was but there would have to be this compelling evidence.
I think the Supreme Court in Nebraska applied an imminently impending test when it analyzed the district court's concerns about, that was pretrial publicity. I sure don't read it as doing that.
I believe Nebraska evidence, one thing that it emphasized, for example, is the need for evidence in the record to support the restrictions, which was absent in that case.
No. I don't see assessing the quote probable publicity, right? And he was justified including that there would be publicity based in part on common human experience that publicity might impair the defendant's right to a fair trial. I'm reading from 562 and 563 of the opinion here. A clear and present danger that pretrial publicity could impinge on the right to a fair trial. Of course, his conclusion as to impact of such a publicity on prospective jurors was of necessity speculative, dealing as he was with factors unknown and unknowable. That does not sound at all to me like you've wrapped yourself around Nebraska versus Stewart. So I just want to make sure that that language from the Supreme Court, which of course is controlling on us, is what you're talking about as the predicate for the district court's showing of a need to impose some sort of restriction.
Yeah, I believe that decision goes on to say.
Oh, no, it validates the terms of that specific restriction, but this is prong one. Do we need to do something? Court breaks it up into separate little things, right? Then goes on to say there were other aspects of that very, very broad order that were a problem. But the need to do something, and the district court's entitlement to do something that is going to affect speech, can be based on the Nebraska showing. That's your position, because you've embraced that case, correct?
I don't believe that opinion means that you can just speculate that you need a showing on part one.
I've told you what it says. I'm not asking, you can read the whole paragraph. I'm sure you've read it many times because you rely on this case extensively. Do you agree, or are you asking us to disagree with what the Supreme Court said was a sufficient predicate for some action? Not the order in that case, but for some prophylactic action by the district court to protect the criminal process.
I believe the court should follow Nebraska. I agree that court should,
including that
but
part.
I disagree with the way that paragraph has been interpreted.
Mr. Sauer, can I ask you if the district court entered an order restricting a criminal defendant from making comments about individual jurors, and the defendant were a candidate for public office, would that order violate the First Amendment?
It would depend on the context, but I do concede there'd be facts that could justify an order like that.
It would depend on the context.
I think so. Yes.
There's a situation in which, let's say the district judge prophylactically has a very powerful and vocal defendant in the case, and jurors are, it's their civic duty to participate, and as a more open measure than having a sequestered jury, the district judge wants to protect the jurors and says no public comments about any of the individual juries. You think it would depend on the context whether that order was consistent with the First Amendment?
I'd say two things. We don't dispute that there could be an impaneling of an anonymous jury here, which I think is the hypothetical.
Well, no, I was saying
in fact,
a
we offer that
non-anonymous
as an alternative
jury and a
restriction.
protection of the jurors.
I think it's saying, hey, the jurors are anonymous, don't post anything.
No, I'm saying a non-anonymous jury. And the question is whether the district judge, consistent with the First Amendment, can say off limits to comment specifically about the jurors.
That's almost identical to the facts of Capital Cities Media, where Justice Brennan, I think, stayed a rule that said you can't talk about the jurors because what was being said about the jurors was already in the public domain. He said, I can imagine a justification that would justify that. So that's why I say it may depend on the context.
Really? So
Yeah, is the information in the public domain
with
already?
the internet
then?
nowadays, the address of every juror might well be in public domain. So district court issues the order.
I should
The
call it.
district court issues the order that Judge Pillard referenced. And a criminal defendant then tweets out to the world, here's the name and addresses of the jurors deciding my case.
If it got in the public domain some other way.
It's already in the public domain, yes.
If it's in the public, what happened in Capital Cities Media is this was put in the public domain by the court. There was an open hearing.
No,
where
that's not
it
my
was not an
hypothetical. My
anonymous
hypothetical is, the world has changed since that time period now. And the amount of information about any individual, including their address, it's pretty easy to find. So if the defendant said, well, I can't tell the name of the jurors because I've been told not to. But here's the addresses of the unnamed jurors, which is very easy. That's already out there in public domain, right? You can just find that with Google.
You can't, I think, let me put it this way. I don't dispute that the First Amendment would allow a gag order from promoting individual address information of jurors with the caveat that, again, Capital Cities Media would probably govern in that situation. If it was a situation where that would have already been publicized by the court, Justice Brennan said there's no possible justification for that. I mean,
but what about now? I mean, in a situation where there isn't any publication of these individuals' relationship to this case.
Right, that I think would be a huge problem, right? That would not, in other words, as I understand the hypothetical, is that no one knows who the jurors are, or no one can link those names, John Smith and Susie Jones, to those addresses. But the defendant says, here's the addresses that go to the jurors. That's very different from Capital Cities Media. I don't dispute that.
What even if they were public, because they weren't sequestered, they're not yet public. Nobody's published that. Nobody's put it out. But they just are, as Judge Millett was saying, if you have a little bit of information about a person, you can find out a lot. But can the judge say, fine, these people can live in public, but they can't be posted for millions of people by someone who it's not a heckler's veto, really. It's a cheerleading squad that is going to come out and amplify or act on and perhaps overreact.
I think the case would have to be assessed under Capital Cities Media.
You
We would
that.
not. I mean, keep in mind that we contend that protecting the anonymity of jurors in this case is an alternative measure that should have been considered and wasn't. It's something that we've been essentially advocating for in our briefing in this case. So it's a situation where, First Amendment or not, I don't foresee any challenge to it, because we would view that as a less restrictive alternative than dragging the president's court.
I'm not trying to manage this case, which the district judge, we all know, is very able to do. I'm asking about the hypothetical is to probe the nature of your position, and it is revealing of, the fortitude that you accord to the First Amendment and the really lack of any role for orders protecting the judicial process. And that's what I'm hearing. And so it was instructive to me to hear your answer to that.
In any event, for all the reasons we've said in our briefs, we ask the court to
Sorry,
reverse the
Can I
gag
ask
order.
you one more?
Sure, yes, Your Honor.
I'm sorry, we'll let you rest. I apologize that it's been long, but it's been a helpful discussion. Thank you. It's the night, and to be clear, you know far more than me about who the prospective witnesses in this case are, but let's assume former Vice President Mike Pence is going to testify. And it's the night before his testimony. Could the defendant tweet out, Mike Pence can still fix this. Mike Pence can still do the right thing
Yeah, why couldn't he say
if
that?
he says the right stuff tomorrow?
That would be more problematic than the statements we have in the record. However, you should weigh the fact that, is there any reasonable prospect of influencing former Vice President Pence's testimony? Nobody
No.
contends that any statement of
So
the
I'm sorry,
defendant might influence it.
So you're right, I was not specific enough. First, does that count as a communication to a witness?
Again, I would give the answers. I know we had a discussion of this before. I'd give the
I've
answers.
told you,
I
it's
gave before.
tweeted.
Depending on
It's
context.
tweeted out. I've told you that is the full text of the tweet, and it's tweeted out on his social media platform.
And is it responding to something that Vice President Pence said, or is it said in a
It
vacuum?
is the night, this is the sum total of facts you're not going to find anymore. You're not going to get any more context. This is it. The night before he's scheduled to testify. Well, I'll give you one more fact. It's public record that he is testifying the next day. And that message goes out. Is that, first of all, is that communicating with the witness?
If it's
Violation
just,
of the release conditions.
if it's just broadcasting a statement of court political speech on social media, likely not.
Okay. Is that something that the district court could prohibit consistent with your First Amendment test?
Only if it was based on a compelling evidentiary showing of an actual threat to
No,
the administration
no,
of justice.
there's no
The
more
decision-
showing. She's the
Only
district court.
after it's happened.
No, oh, you're right. So so you're saying that if Mike Pence then calls in sick the next day, sorry, laryngitis, can't testify, then we can say you can't post about Mike Pence. That can't be the test.
But if he
But you're
says
saying
Mike
there's no
Pence can
prophylactic
do,
rule.
or Mike Pence can
You're
say,
saying that
as
doesn't
opposed to
violate communication with
Pence
witnesses.
you
And you're
can do,
saying
or
there's
Mike
no
Pence you
prophylactic
can
rule,
say,
there's no
that I
circle
think
around that communication with
communication with the witness.
witnesses.
I'm
That the district court could draw, like prohibit that statement,
I'm saying that
consistent with the First Amendment.
that prophylaxis would have to be based on a compelling evidentiary showing of likelihood to influence
The district
testimony
court
or some
says,
interest
the
of that
district
nature.
court says, I conclude that that communication was, one, attempted communication with a witness, and in fact, likely in a completed communication with a witness, and two, was designed to and could affect a reasonable person's testimony before the court. So now you've got those two fact findings.
Those fact findings would have to be based on evidence. If
I
those
don't know
fact
if Mike
findings.
You're
were
Pence
just
made,
not
then
going to
you
let
have
the
a-
district court
then you have a
say
much-
you can't in advance, the night before trial, encourage somebody's, the content of their testimony. Your test doesn't even allow for that.
If there's
But
no
maybe that's just
reasonable
my
prospect.
opinion.
that
Your
it
test
actually
doesn't
would
allow for
influence-
that.
If there is no reasonable prospect and no evidence that would actually influence
Which
anybody's
there's not going to
testimony.
be.
And again, it is not my test.
Then there's not, so there's no prophylaxis. Because when you say, I want evidence was actually going to influence, what you want is, it has to be criminal. Otherwise, the district court can't protect it. Because if there's actual influence, that's a crime, or actual evidence, that's a crime. So just to be clear, we're back, I think where we started is that,
I think I would stand on my prior responses.
okay. Any other questions? Thank you for your generous time.
Thank you, Your Honor.
We'll hear from the government. We will give you some rebuttal time.
Thank you, Your Honor. May it please the court, Cecil Van Deventer on behalf of the United States. The district court correctly found that the defendant's well-established practice of using his public platform to target perceived adversaries, including trial participants in this case, poses a significant and immediate risk to the fairness and integrity of these proceedings. The order that the district court crafted to address those risks should be affirmed for three principal reasons. First, the unique factual record before the district court. Second, the unusual narrowness of the resulting order. And third, the recent evidence demonstrating that the defendant is fully capable of understanding and applying with the order while it's in effect. Defense
So I just want
contrary,
to follow up. You just said significant and immediate risk. So you're not embracing the Gentile test?
no, Your Honor, to be clear, the Gentile test is the constitutional test that applies. Significant and immediate risk is the language that the district court found, so it sort of assumed that
Those are kind of different words.
Pardon?
Within the law, those are substantial likelihood of material prejudice and significant and immediate risk, I think, are two different legal tests.
I completely agree, Your Honor, and the Gentile test of substantial likelihood of material prejudice is the correct legal test. But because the district court incorporated the higher test of the defendant proffer, that is the significant and immediate risk test, I think that does inform the scope of the order and informs the findings that the district court made. But to be clear, the Gentile test is the one that applies.
Mr. Van Deventer, where is the finding that you're relying on?
It's on page 2 of the order, Your Honor.
The follow-on order, the order.
Yes, this is at Joint Appendix page number 230.
Yeah. The court finds
Yes,
that such statements pose a significant and immediate risk,
exactly.
that witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted, harassed, or threats. And 2, attorneys, public servants, and other court staff will themselves become targets for threats and harassment. On the second part, number 2, applying to staffs of the special counsel and of the court, the nexus between the concern that they be targets for threats and harassment and the administration of justice is not entirely apparent from the district court's order. Can you help explain that? I mean, for example, the district judge is not, no speech relating to the district judge is gagged.
That's correct.
And that's in part because we trust that the district judge will not be swayed by anything that the defendant says. How then could the district judge's staff affect the administration of justice?
The district judge's staff?
Yeah, any effect on them of non-criminal harassment and threats?
Well, I think exposing trial participants, whether those are courtroom staff, line prosecutors, or others, to the risk of threats, harassment, and intimidation poses a systemic risk to the fairness and integrity of the proceedings.
How so?
It creates a world in which people who are public servants will have to decide, do I want to handle this type of case? Do I want to press on with the sort of prosecution that we think the facts and the law demand? Or in doing so, will I run the risk that I will be threatened, my family will be threatened, there's a chilling effect and a pall cast over the whole proceedings if the trial participants feel like they're at risk just as a result of their participation in the case. Separately.
And that's, the way you worded that, it made it sound like before they became part of the team, like in the future, other staffs might hesitate before joining the team. Is your submission also that existing staff might quit?
Well, I think there's certainly a risk of that. And certainly the court doesn't have to ask each staff member, how likely are you to quit if your family receives a death threat? I don't think there's any basis to say that in the absence of the likelihood that you will actually be deterred from doing your job, you have to tolerate threats and harassment being directed towards trial participants.
I had just a sort of very specific question. You mentioned the families, and the district court from the bench said that the gag order applied to the families of the staff of the court and the prosecution and the defense counsel, but the written order doesn't reference that provision. But what is the government's position as to whether the order currently applies to family members?
Our position is that it does, Your Honor, for 2 reasons. First, the beginning of the order, of course, incorporates the oral explanation. And as the court said orally, the prohibition on targeting family members, in her words, goes without saying. And so I think in district court's view, because the prohibition extends to these specific categories of trial participants, it necessarily extends to their family members as well.
So as I take it, your position is less a substantive one, that it would affect their impartiality, but is more a question of whether the people would even be willing and able to do the work.
It's partially that it would threaten whether they're willing and able to do the work. It could also threaten the way that they are perceived by the jury.
I know that my friend on the other side has suggested that the district court disavowed any sort of jury taint as a rationale for this order, but I disagree with that. What the district court did disavow was the request by the government to include within the scope of the order posts targeting the jury pool in the District of Columbia. Said that can be dealt with through voir dire. I'm not going to prohibit those statements, but I think the district court very much incorporated the idea of trying the case in the media, polluting the jury pool, prejudicing the jury. If the jury is presented, if the case is presented to the jury by people about whom there's been a months-long persistent drumbeat about their corruption, inflammatory comments about them in the public, that could affect how the jury perceives them.
Counsel, I think.
Are there findings about that in the record?
Well, the court clearly was focused very much not only on threats to trial participants, but the way that this would affect the due administration of justice, the fairness of the trial, and so that I think incorporates concerns about how the trial will be presented to the jury. Absolutely.
So the two mechanisms you've identified, one is that individuals would be de-energized and or deterred from even being on the team, right? And the other is they might be, their impartiality might be tainted in the eyes of the jury.
That's right. It's basically a kind of specific example of trying the case in the media. By the day that the jurors walk into court, they have heard derogatory comments, inflammatory comments about the people that will be presenting the case. That certainly threaten the fairness and integrity of the proceedings.
Isn't that exactly what voir dire is going to sort out?
Voir dire is moderately well situated to address those sorts of concerns, yes, but as Gentile pointed out, the availability of voir dire to sort out these types of prejudicial problems is not kind of dispositive. The court should, in fact, take preventative measures, prophylactic measures to prevent that sort of prejudice in the first place.
Oh, I was just going to say, I heard you to be suggesting that it's not just that folks might be deterred from participating in the case, but that the fact that they and their family are receiving threats might distract, might interfere with their ability to carry out their roles as part of the system of justice. Is that so part of what you're saying?
Absolutely. And if I can make just one factual point, because I know my friend on the other side has emphasized a couple of times the supposed lack of any submission of threats being directed towards the special counsel's office. But I'd point the court to page 85 of the joint appendix, where it specifically says special counsel has been subject to multiple threats, and the specific special counsel's office prosecutor that the defendant has targeted through recent inflammatory public posts has been subject to intimidating communication. So it's not accurate to say that there have been simply no threats or that none were in the record presented to the district court.
Well, but
I'm sorry. I just was going to ask you to elaborate. I think one of your three principal reasons was the evidentiary record.
Yes.
And I appreciate the point you just made, but in discussing what is unique about this evidentiary record, can you please respond to the argument that at least most of what's being relied on here is from 2020, and the fact that in opposing counsel's view, there's been a lot of intense media attention and relatively fewer threats. So I just would like to hear what the strongest points you think are in response to that argument.
Yes, Your Honor. So I think it's important to look at two aspects of the record that was before the district court. The first is the fact that, to my knowledge, there has never been a criminal case, and the defendant certainly has not identified one, in which the defendant has routinely, I believe his word was incessantly, taken to public posting to a national audience to routinely vilify the prosecutors as thugs, as deranged, as lunatics, to malign the court as fraud and hack, and to attack witnesses based on their credibility and the substance of their anticipated testimony, calling them liars, cowards, weak, saying one deserves the punishment of death. That alone, I think, would be sufficient for the district court to act. But you combine that with a record going back a number of years, but continuing to this day, in which numerous people have been targeted as a result of the defendant's posts. And I think there are 16 different people that are documented in the record. 8 of them are from the 2020-2021 period, which I believe, Judge Garcia, as you noted, is hardly some tangential time period to this case. This is exactly the core of what this case is all about, this period after the election. Some of those, of course, go through today. We talked about, of course, the threat to Judge Chutkan, and then We have threats to the district attorney in New York, threats to the district attorney and the sheriff of Fulton County, threats to the former president, threats into the judge chambers presiding over the ongoing civil trial. These are all from the last few weeks. So the notion that there was some dynamic that existed in 2020 that has since abated or gone stale, I think is wrong.
How do we, how do we know what he gets held accountable for? I mean, this is the internet era.
Good question.
He's a high-profile public figure who posts. It's lots and lots and lots of followers. But it's also covered on news channels that have listeners, and newspapers that have readers, and all manner of media can communicate his words to people of the public. How does a district court reasonably decide
Or other people's opinions
which
that are put out there?
postings he is responsible for prompting adverse conduct, resulting adverse conduct, and which are he's protesting, he's expressing his views as the First Amendment allows, and in a social media world cannot be held responsible for what everyone anywhere in the United States does when they hear about it.
Two answers to that, Your Honor. I think first is the sheer number of occurrences. So certainly if there had been one time when he posted something derogatory about a person, and then at some point thereafter that person was a recipient of a threat, I don't think we would be here. The sheer number combined with the testimony of the people who experienced it on the receiving end, who said, what changed when the defendant tweeted about me was I started getting much more graphic, much more specific, much more pervasive threats. When, as one of the witnesses, a poll worker in Georgia testified to Congress.
Do you have any of that with respect to his statements about this criminal trial?
No, none of the people who have been directly threatened as a result of this criminal trial have testified about that exact phenomenon. Although, again, I think the context around the threat to the district court is worth emphasizing. So the indictment came down on August 1st. The arraignment was on August 3rd. Before traveling to the arraignment, he issued a public statement saying, unfair venue, unfair judge. The next day, he posted, if you go after me, I'm coming after you. And the day after that, the district court received the death threat. So yes, it's a matter of inference, circumstantial evidence, of course, but the district court made those findings. And to Judge Pillage's point earlier, those are findings of historical fact that should be reviewed for clear error.
And because I know you referred us to the district court on page JA85. Special counsel has been subject to multiple threats. That's one thing. But the special counsel's office has been targeted through inflammatory public posts. So, I guess intimidating communications and those inflammatory public posts.
Special counsel's offices are
But doesn't
also
the
public
First Amendment
figures,
protect?
all under those
And this is, to be clear, these comments have come in the course of a presidential campaign, or I guess at this point, a party nomination campaign. Inflammatory language?
So, Your Honor, our position.
Surely there has, I asked them about balance for the protecting the criminal process, but I guess I'm asking your position, which doesn't seem to give much balance at all to the First Amendment's vigorous protection of political speech, and the notion that high-profile public figures or governmental officials who've taken on enormous responsibility like prosecutors can't stand up to some inflammatory language seems to me to contradict Supreme Court precedent, and seems to me sort of a very troubling lack of balance on the free speech side on the part of the prosecution in this case.
Exactly.
Our position, Your Honor, is not that these statements in a vacuum are unprotected. It's that Gentile presupposes that the restricted language is protected. As Justice Kennedy said there, that was classic political speech directed towards the government. Nevertheless, it can be proscribed if there's a substantial likelihood of material prejudice to the proceedings.
And how do inflammatory posts about the special prosecutor create a substantial threat of material prejudice to the proceeding?
So that's when I think we tie it back to the record, which is that There is a pattern, there's a dynamic. It's very clear that when the defendant engaged in repeated inflammatory personal attacks on someone, there's a causal link between that person then receiving harassment, threats, and intimidation. And as I was,
Well, if there's actual threats, then that's a crime and that can be dealt with.
Be prosecuted.
yes,
Yep.
but
If
also,
it's short of that, if it's, I mean, you know, again, we had, you know, the Fifth and Sixth Circuit cases, and if you've got someone who says that prosecutor's out to get me, that I think there's allegations the prosecutor's racist in one of the cases. This is all a political vendetta. Are those things allowed? They're pretty inflammatory.
well,
Calling someone a racist is pretty inflammatory.
yes, Your Honor, the district court tried to craft a very narrow order that allows him ample room to criticize the prosecution as politically
How does it do
motivated.
that if you say you can't target the special counsel?
Well, the district court, I think, draws a very clear distinction between attacking institutions and processes on the one hand and attacking individual trial participants on the other. So saying that the prosecution is politically motivated.
The prosecution is an governmental institution, right? It's not a personal job. It is the government, right? When the prosecution speaks, even when it's a independent counsel, they speak for the United States government. So I'm not sure that line works so well.
No, that's absolutely right. Maybe I was unclear. What I'm saying is attacks on the prosecution, calling it unfair, calling it politically motivated, those are all fair game.
But you can't say the prosecutor is politically motivated.
That, I think, well,
That would certainly count as targeting the prosecutor.
I think the special counsel himself is a somewhat unique case because he is both an individual trial participant and very much represents the institutional interests of the Department of Justice. So for him, we would concede that merely kind of referencing him or criticizing him.
The prosecutor's working with him and under his supervision. You can't say they're politically motivated.
If you're talking about individual line prosecutors, particularly if you're mentioning them by name, then no, the mechanism for that, as Judge Pillard alluded to, is file a motion. Certainly, if you think that there's some political bias.
He has to file a motion every single time he wants to say all the prosecutors in the office are politically biased against me.
Exactly.
I mean, it might not be true, factually, might be, who knows? But I'm not suggesting that it is. It's just a question. But if
It goes
if
against
in his
core
mind,
political
in his
speech.
view, all the prosecutors in the office are politically biased against me, he has to file a motion before he can say that? That's not much, taking much account of the First Amendment interests at stake.
Well, I think if it's at such a high level of generality, everyone.
How can you tell that from this order? That's definitely targeting folks in the special counsel's office.
This judge
It's definitely
is asking a
prohibited.
great
So I
question.
think that's why you're saying he has to go file a motion to make sure he's allowed to say that.
The motion I'm alluding to, Your Honor, is not a motion to ask for permission to speak about it. What I'm talking about is avoiding a two-track process here, where there are claims that get presented in court and then a whole separate effort to kind of malign the people involved, suggest that there's some improper purpose or motivation or bias that's never even raised with the court. I mean, the defendant is free, of course, if he thinks that there's a colorable claim of prosecutorial misconduct or prejudice, likewise judicial, to file a motion seeking disqualification, dismissal, and then he can talk about the fact that those findings or filings exist. But what he can't do is say, I'm going to have this turning narrative that there is a political bias, but I've never presented it to the court.
But, so imagine, I understand he hasn't participated in debates thus far, but if he were to choose to participate in a debate and the other folks who are competing for the Republican nomination, let's just say they spend a lot of time talking about, you're an indicted felon, you're being prosecuted by the United States government, they'll prognosticate, you could be found to be a criminal before the election, and they have all this evidence against you, the millions of pages that they talk about in the record here. And so they're going on and on and on during the debate about this criminal prosecution. And you're telling me he can't say public record prosecutors paid by the taxpayers, your names are public record, A, B, and C prosecutors. It's all a political vendetta. They all are doing the bidding of Joe Biden. Yeah, I'm not saying anything's true here. I'm just saying, that's not the test for free speech in this country, thankfully. He can't stand on the stage and say that.
So, Your Honor, he can certainly say this politically motivated prosecution brought by my political opponent, the Department of Justice is corrupt. I will be vindicated at trial, all of that stuff. But when he starts naming
He has to
individuals,
speak mismanners while everyone else is throwing targets at him.
Well, and it can't be that he can't mention Mr. Smith, who, I mean, for most people in the United States, given the number of legal battles in which this defendant is embroiled, the only, the easiest way people have of referring to this case as opposed to the others is Jack Smith. Surely he has a thick enough skin. He's on this team. The two interests that you mentioned, which are one, the person would be dissuaded. I have little doubt that he will not be dissuaded. And then the other, that his impartiality or integrity would be impugned in the face of the jury. First of all, I'm not sure I see the district court having made any such determination or even followed that reasoning. Am I missing something supportive of that link?
well, I think it's very clear that the district court is, because the whole rationale is premised on ensuring the integrity of the proceedings and the fairness of the trial. Of course, the court wants to make sure that the jury is not presented with extraneous information that would not be admissible in court that could prejudice their determinations. And I think part and parcel of that is how they view the trial participants. But to go back to—
How can, I mean, I guess Judge Millett has already asked these questions. Given all of the issues that are both before the court in this case and before the public in the election, it's hard to see how this portion of the restrictive order is going to succeed in preventing a trial in the court of public opinion.
Well, again,
I took her order to more be focused on protecting individuals, protecting witnesses from threats, from harassment, from fawning and efforts to positively motivate them and the like, not to shield the veneer. But you take a different view.
Well, no, I think I would agree that that is the principal motivation, certainly shielding people from harassment, threats, and intimidation, both witnesses and other trial participants. And certainly that includes, the line prosecutors handling the case. Again, special counsel himself is a slightly different case because he is both an individual trial participant and a representative of the institution. And so that's why we would say that merely mentioning him would not violate the order, that would not be targeting. Whereas in the debate, Your Honor, if—
I do want to hear that answer. I was going to ask the question, but before I do, I'm still struggling with how you distinguish. I mean, maybe the special prosecutor is in somewhat different place, but that does not mean that prosecutors working with him, assistant prosecutors, or whatever the title, deputies, are not public figures themselves. Would you agree?
They can be public figures for certain purposes.
Okay,
but
so then it shouldn't matter. I can't on the debate stage, and I guess now you can do that answer on the debate stage. Why can't the defendant say A, B, and C, whoever is the prosecutorial team in the particular case, biased,
Your Honor,
racist, anti-American,
I think
whatever deplorable adjectives.
I think in context, I think you'd have to view that as basically the meddlesome priest problem. Why is he mentioning individual line prosecutors, but for holding them up to scorn in the public and increasing the likelihood of their
Well, I
being
have to
targeted?
say they make a good point that I'm not sure that will no one rid me of this meddlesome priest might not have a more First Amendment debate. You'd have to really make the showing. If it's sort of the Godfather, will someone get rid of the snitch for me? That's one thing, but you'd have to make that kind of showing. But, if a high level, if someone high up says, well, someone just make this problem go away, Could he not say, will someone just make these cases go away? It's a political vendetta. Let the American people decide. Can he not say that?
Someone make these cases go away, this political vendetta, that would be consistent with the order. That would not violate it, yes.
So tell me about your debate, what your view of, boy, it would be really hard in a debate when everyone else is going at you full bore, and, you know, your attorneys will have to have scripted little things that you can say.
Your Honor, I respectfully disagree that there be anything particularly challenging about a rule that says naming individual line prosecutors somehow, you know, is too complicated, too hard to follow. He can say everything he wants to say.
You don't think he can name line prosecutors by name?
I think that would be presumptively an act of targeting. Context could suggest otherwise, but naming.
Well, what context do you need? I've got my debate here. It's a matter of public record. You're receiving the pay of, you're paid by the taxpayers, and he can't say by name that person.
Even once you've appeared and spoken in open court in the case against him.
Our view is that is presumptively targeting within the meaning of the order, but
It's targeting because you're not the special counsel.
that's right. It's targeting because
What's your definition of target?
targeting, in our view, means singling someone out for the sort of negative attention that poses a significant immediate risk of their being a recipient of threats, harassment, and
But
intimidation.
negative is viewpoint based. So the district court corrected, the reason she chose targeting instead of the language that you proposed was because she didn't want to make the order viewpoint based and make it more defensible. But I think you're right that the targeting does raise a little bit of unclarity. And I wonder whether you comment on the proposed alternative that I mentioned to Mr. Sauer, which is that if the order prohibited comment on any reasonably foreseeable witness or the court staff, but let me limit it to the witnesses, reasonably foreseeable witness because of witnesses' potential participation in the trial. Because one of the difficulties is disaggregating the public figures who are in the political arena in other ways, writing books or, you know, and who are anticipated to testify at trial here. Is that, does that do the work that you need? Does it pose different constitutional concerns that I'm not appreciating?
I don't think it poses any additional constitutional concerns. I think that would be a perfectly valid gloss on that portion of targeting. I do think it omits another important component, which is this concern about exposing people to threats, harassment, intimidation. So if the defendant were to say, you know, not with any reference to their testimony, but say this person, you know, is a coward, a liar, and a treason, and deserves the punishment of death, without any reference to what the substance of their testimony would be, I think that would still violate the order.
Except couldn't you, you know, given context, if there's no other reason that this person's being targeted, you said the reason they're talking about that is because of the testimony. Whereas, you know, when General Milley has written a book and has spoken publicly about his efforts to shield the world from the consequences of the defendant's conduct, that has got to be fair game.
Certainly fair game to comment on it. No, I don't think anybody suggests otherwise. But I think it's
So what's not fair game? So he can comment.
Yes.
And he can comment very critically. What can he not do?
Use the sort of inflammatory language that poses a significant risk that they will be subject to threats, harassment, and intimidation. And so, you know, I don't think the line between saying conduct like this by the chairman of the Joint Chiefs of Staff is intolerable in democratic society, and saying, on the other hand, this warrants the punishment of death is a particularly abstract or difficult line to draw.
Yeah. So it's comments that will predictably trigger the loyalist zeal, or what Mr. Sauer refers to as the heckler's veto. And that just took me a long time to figure out what he was referring to in terms of heckler's veto. But it's the triggering third-party conduct, what I would tag as the loyalist zeal.
That's right.
That's what you're aiming at, is that the defendant can comment on all kinds of things, but when he does so in a way likely to trigger this excessive zeal, that is how you read the district court is targeting that kind of
Yes,
or barring that kind of speech.
Yes, Ron. And going back, Judge Millett, to
Well, so
your,
the post, I'm sorry,
well,
didn't interrupt you, answer my questions. Go ahead, but then I do want to follow up more on this Mark Milley thing, General Milley.
going back to the question about, what can he say during the debate? I mean, I think it's also worth looking at some of the things that he said in TV interviews and even in one of the posts that the district court used as an example in the order denying the motion to stay of what's permissible. So in that post, he's talking about, the political bias in this prosecution, how it's been brought by the incumbent administration. And he says, at trial, we will 100% prove with evidence that, that the election, that I won the election and so forth. He can always say what every other criminal defendant in every other case says. Once we get to trial, I'm going to prove all this with evidence. The necessity to single out trial participants that have not been the subject of any sort of litigation, just as sort of personal singling out just to put their name in the public, I think is presumptively an act of targeting.
So if I'm on J130, which is the General Milley post, can you tell me which parts of that were, because this was the day after General Milley did an interview about his book. It wasn't right after the indictment. It says nothing about the criminal trial or General Milley's prospective role or not in it. And so tell me, what of this, is everything okay except the punishment would have been death? Is everything else okay?
Yes, I would say so. And I think the important context to know when reviewing.
Is he wrong that, I'm not talking factually about this particular situation about which obviously we have none of the details before us, but is it wrong, at least historically, that, again, not talking about this conduct in particular, but some acts of treason were punishable by death?
No, that's not wrong. And the
Okay.
district court was free to.
Isn't that all he said?
Well, the district court was free to decide whether he included that language to make kind of the abstract historical point about what the punishment for treason was in times gone by, or was he saying it
Well, what do you,
implicitly
I think because I've talked at least about the need to balance, and, it's not how I want my children to speak, but that's really not the question. And so the question is, what in here in this post, including the reference to historical capital punishment for treason, connects that to the criminal trial? Connects anything about this post to the criminal trial, the criminal process, General Milley's potential or not, I have no idea, participation in the criminal trial?
So on its face, it doesn't allude to his testimony, but it's important
The
to.
timing, you don't have the timing. It's
No,
not
we
like
do.
the day of that.
We do have an important distinction in timing, which is that the information about General Milley and his conversations with China, that all came out in 2021.
Mhm.
The defendant had a reaction to that news then. He was not calling for him to be put to death, suggesting that death was an appropriate punishment. He started doing that once he was indicted.
Wasn't this the day after General Milley did an interview about his book?
Yes,
Comments?
yes.
Okay, well,
So it was in the news again, but his reaction to it, post-indictment, once he knew that General Milley was a potential trial witness, was very different than what his reaction was in 2021 when General Milley was not a potential trial witness against him. And so
pretty much once there's an indictment, he just can't, he can't, under this order, he just really can't say anything about folks who are either known or reasonably foreseeable witnesses.
I disagree. I think
Can you say?
there's a perfectly comprehensible line between the sorts of things that use inflammatory and disparaging language that are
Can you say
likely.
anything disparaging
I think
about someone? You just said inflammatory, disparaging, so take off inflammatory. Is he allowed to say anything disparaging about someone? We'll make it easy, that he knows is going to be a witness now that there's been an indictment. Between now and the trial, obviously after trial is a different thing.
I think he can criticize them so long as he's not using either inflammatory language or attacking their credibility in a way that's going to shape how the jury sees them. That's another example of trying the case in the media.
I'm trying to understand with respect to these high public figures. They, like everyone else in the country, are protected against true threats. They're protected against criminal efforts to affect their testimony. They can be prosecuted for that. I mean, the defendant could be prosecuted for threatening them in violation of the criminal law. But when we step back and think about a protective order to protect the integrity of the proceeding, the mechanism is that their testimony would be affected.
I think
That's very hard for me to imagine.
I don't think that the test is whether any particular witness who is targeted will actually change their testimony or refuse to testify.
Or that it would be reasonably foreseeable that, because you're right, this is a prophylactic situation. I would assume that their testimony would not be affected, that Mr. Barr, General Milley, former Vice President Pence. I take part of your position to be that there's a performance of their vulnerability that then would affect unknown non-public figure witnesses.
That's exactly right. There's a clear kind of knock-on effect. If you're a witness out there, and there are many, many witnesses who fall in this category, not public officials, no recourse to marshals or Secret Service protection. If they see that General Milley can be suggested he should be put to death, if they see the former chief of staff can be called a coward, then they are going to absolutely be chilled. They say, why would I come forward and give the facts that I know about this case if the result is going to be that I'll be subject to the same treatment?
This is a very small question, and it reveals my lack of technical prowess, but is there any way preventatively to protect someone's technology? Like, let's say I'm a prospective juror. Can I be protected technologically from like doxing?
You're asking about whether there are available technology that would sort of remove your personal information from the internet?
Or just that would filter, I don't know, that if things start coming through that are so fast and furious from strangers. Because it does seem like there's a real phenomenon that is actually quite disabling and terrifying.
Yes, absolutely there is.
But I'm wondering whether there are ways in anticipation of that can be mitigated short of, because we do have, as you appreciate, the problem of speech by the defendant, and then it has the knock-on effect with the loyalists' zeal, and that's then what causes direct efforts at threatening and harassing individuals. And I just wonder if there's any non-protective order. Are there tools?
I'm not aware of technological tools that would work nearly as well as mitigating this prejudice at the source. If they exist, I think they are not widely used and not easy to incorporate, particularly for every witness and every potential juror and so forth.
I just want to clarify a few things about the scope of the order as you see it. So you mentioned you think that one of the interests in this order is protecting sort of jury perceptions. So one of the examples in the district court transcript is essentially X is a slimy liar. Without any more context, is it the government's view that that's prohibited by this order?
Yes, Your Honor. If it's directed towards a foreseeable trial witness, yes.
So it's Bill Barr goes on 60 Minutes and gives an interview and criticizes Mr. Trump's fitness for office in part January 6th, the events related to January 6th. Mr. Trump can't go online and say everything he just said is false.
Everything he just said is false. I think is different from using either inflammatory language or attacking his credibility directly. I know that that's a little bit of a fine line. But yes, I think if it's a direct attack on credibility or an inflammatory comment that's likely to result in threats and harassment, that's one thing. If it's just a generalized criticism of his performance as the Attorney General or disagreement with what he has said, I think that would be another.
Is slimy liar inflammatory?
I think it's inflammatory and a direct comment on
What
credibility.
if he just said he's a liar?
Well, I think that also would be a comment on credibility that would be prohibited by the order.
So it doesn't have to be, calling someone a liar is itself inflammatory?
That liar itself would not fall into the category of inflammatory.
So any attack on the credibility of someone who's a prospective witness?
Yes, Your Honor.
So it's deeper into the campaign. and someone who is done testifying, but the trial's still going on, goes out and campaigns with the Democratic nominee, brings him up on stage. This is why you should vote for me. Heard what he said about what would happen if we had another Trump administration. He's got a whole book. It's on sale at the table over there, special discount for people attending the rally. But now stand up here at the podium, Mr. X, and tell us about your experiences working with him and why I should be president instead of him. All this is going on, and you are telling me that former President Trump, the First Amendment balance in the criminal process would not allow him to say, Mr. X is a liar. He's lying in what he said. I was a good president. He can't say that?
He can certainly say I was a good president. I disagree with
He
everything that he
can't,
said.
he can't, I'm sorry, he can say I disagree, but he can't say he lied.
These are corner cases, I would agree, where
No, you didn't have any hesitation in telling me that he couldn't do it. I don't think, it didn't seem like a tough case to you. You said, no, he can't call anyone a liar. You said can't comment on credibility.
yes, we think commenting on a witness's credibility about the substance of their testimony is
No,
presumptively a
he's
violation.
commenting on the credibility about what they said at the political rally.
That's right. And if it goes to the substance of their testimony and it's about their credibility, then it's presumptively violative.
Let's say 10% of what he said related to the trial testimony that Mr. X gave the day before, and 90% did not, but just was a tirade against the political opponent of the person on whose behalf he's speaking, a tirade against the former President Trump in the midst of the election.
So he has a lot of space to say, I disagree with everything that he said. We're going to prove at trial that what he said is not true. But when he's trying the case in the media and, look, a single word like that's a lie, that's a liar, I think it's extremely unlikely that the government's not going to be moving.
Is it
for an
covered
order
by
show
the
cause.
order? I don't want to know whether the government's moving forward. I want to know whether it falls within the scope of this order that is being challenged on First Amendment grounds. And I think you've said repeatedly that, yes, it is.
Yes.
Maybe you'll exercise restraint, but
Yes.
he says that when someone has just attacked him viciously in the press with their views, I shouldn't say attacked him, but has unloaded some of it is very political dynamite against him. And he can't say, can he say it's untrue? Would that person that is untrue? Can he say that?
Yeah, yes.
Okay, but he can't say that person is an untruth speaker.
If it's about the
Can he say they're an untruth speaker?
yes, he
But
can
can't say
that,
they're a liar.
but the sorts of attacks on credibility, he is a liar.
So his attorneys, when he says, here's my speech, here's what I want to say, and they have to X out liar and put in untruth speaker.
Now they have to put an untruth speaker. They have to avoid a direct attack.
Do you have
on
another word we could put in instead of untruth speaker?
Sure. What he said was untrue, and here's why.
No, he wants to talk about that person's character penchant for untruthfulness.
That's right. I think that's exactly the point. If he's talking about his character for truthfulness or untruthfulness, that is
I mean,
trying the case in the media.
it's just, there's a balance that has to be undertaken here. And it's a very difficult balance in this context. And we certainly want to make sure that the criminal trial process and its integrity and its truth-finding function are protected. But we've got to use a careful scalpel here and not step into really sort of skewing the political arena, don't we?
I agree with that, but I think the order as properly interpreted strikes the appropriate balance. It leaves him ample room to respond to these things, to say that these things are untrue, to say what defendants in every case.
And what is the strongest, I mean, a lot of the cases, as you're well aware, about the interest in a fair trial are in cases that are protecting criminal defendants against a prejudice process, bias in the process. There are some mostly dicta about the government's interest or the broader systemic interest in a fair trial. What's your strongest support for the order in terms of the government's interest?
That's right. So the Sixth Amendment right is a right to a fair trial by an impartial jury. And as the court says in Gentile, which of course was speech by a defense attorney, the state also has a right, an interest in a fair trial that needs to be protected by prohibiting prejudicial extrajudicial speech. And that's consistent with how the court treats other Sixth Amendment rights. So for example, the defendant has a right to a speedy trial. He doesn't have a right to delay his trial for as long as he wants because the government and the public also have an interest in a speedy trial, even though it's textually vested in the defendant. Likewise, the defendant has a right to a trial by jury, but he doesn't have a right to unilaterally demand a bench trial if the government, on behalf of the public, thinks a jury trial is more appropriate. So there's nothing unusual about saying that the right to an impartial jury means that the government also has a right to a fair trial.
In the order, one of the terms is political rival. How would you define that? Is that, I mean, now former Vice President Pence is no longer running. Are there no political rivals any longer, or is a political rival, is it really a synonym for a public figure like Milley, Barr, the like?
I think the court intended it to be equivalent to people who are running against him. If the court felt like it was necessary to interpret political figure more broadly to encompass people like the former Attorney General, former Joint Chiefs of Staff, we would understand, that I think could be a permissible gloss if necessary to make this order sufficiently narrow. But I think what the district court intended was to refer to people who are running against him. If I may make just a couple.
Let me just ask one more thing. You had, I believe, when you sought the order that's before us, we'd also asked the district court to amend the conditions of release with similar terminology, and the district court denied that. What's at stake as between putting terms like this in the conditions of release and doing an order under Rule 57?
So two thoughts on that, Your Honor. The first, which I hope is not too tangential to your question, but I do think my friend's concession that these sorts of restrictions, including on contacting witnesses and other portions of the Bail Reform Act, are consistent with the First Amendment, I think is a fatal concession to their whole legal standard. I mean, if it's true that a defendant is consistent with the First Amendment, can be restricted from communicating with witnesses, associating with other people, just on the standard of reasonable assurance of the safety of the community, then I think it follows from that their clear and present danger test and their demand for evidence proving its imminence can't be right. What's at stake in doing it under—
But don't individual terms that are imposed under the Bail Reform Act also receive constitutional scrutiny?
Constitutional scrutiny, but the test is, will this reasonably assure their appearance at trial or the safety of any person or of the community? It's not, is there compelling evidence that a clear and present danger?
Well, that's the statutory test. We don't really know what the First Amendment test is, right? I don't think we've been cited cases that involve challenge to the bail condition. Is that right?
Well, that's right, Your Honor, but I think it would be quite extraordinary to suggest that his position here somehow would, I think his position here, if carried to its logical conclusion, would necessarily cast doubt on the constitutionality of all of these routinely imposed provisions of the Bail Reform Act when courts have upheld those for years.
I think it would have to be, there would have to be a constitutional analysis. Isn't that what Salerno did?
Yes.
And so something that's a more fulsome speech restriction would have to be looked at under the Constitution.
Well, it'd have to be, certainly have to be looked at.
And it wouldn't be whether it would reasonably assure their appearance at trial.
I think it would. I think these sorts of restrictions are imposed all the time. Don't contact this particular person. Don't, post the witness list on social media. These are done if they reasonably assure the safety of another person or the appearance of the person. And I don't think any court has really cast doubt on their constitutionality. Going back to the question.
But yeah, you had been more broadly responding to the question that I asked about sort of what's at stake, whether it's a Rule 57 order or a condition of pretrial release.
That's right. So we requested modification of the bail conditions in response to the motion to stay. The district court denied it on procedural grounds without prejudice. It may well be that at some point in the future, either we or the district court find it necessary to also modify conditions of release. The remedies that are available are a little bit different. The procedures are a little bit different. Here, there would have to be, a show cause hearing if there's a violation, proof of willful violation for criminal contempt. So the mechanisms are slightly different, the standards are slightly different, but I don't think the constitutional analysis is any different.
So the show cause hearing and proof of state of mind for violation of the Rule 57 order?
That's right.
And for revocation of bail or release?
It'd be clear and convincing evidence of a violation of a condition. So not a ton of daylight between those, but just a slightly different standard.
You have, sorry, were you going to, thought you were going to make a
Please.
comment before you. You rely on the Gentile case from the Supreme Court. But your friend on the other side makes a quite relevant point that an awful lot of the language in there and analysis was focused on the fact that it was counsel. Attorneys choose their profession, they take oaths, they are officers of the court. Don't know of anybody who chooses to be a criminal defendant. And we have, as part of our criminal trial process, very robust protections for criminal defendants. And it's true, most criminal defendants, on the advice of counsel, say nothing publicly. But if a criminal defendant wishes to speak, why would the genteel balance that was struck there apply specifically to criminal defendants who really have a special status, a special protected status, and their ability to do, to resist the government's action against them?
So I think Gentile, as I think Judge Garcia was mentioning, his colloquy with my friend, really clarifies that what the relevant distinction is trial participants on the one hand, strangers to the litigation on the other. And that draws on Shepard, which lists trial participants, including the accused, alongside defense counsel as people whose speech can be restricted if it poses a substantial likelihood of material prejudice to the proceedings. In Gentile, I think it was important to the court to explain why an attorney also was subject to those same restrictions. It might not be obvious to the lay reader why an attorney can be prohibited from making certain extrajudicial statements. I think the justification for why a defendant who is been charged by the grand jury with committing felony is subject to similar or comparable restrictions, I think is almost more self-evident. As Salerno said, criminal defendants are routinely subject to.
If I may, I think part of the question was specifically about Gentile's emphasis on the history of regulation of attorney speech. Are you saying that there's a similar tradition and history of the regulation of criminal defendant speech to that same degree?
I think it's.
Or is it just the other pieces of the opinion?
No, I think why Gentile included a long discussion of the historic regulation of attorneys has to do with the fact that they needed a justification to help explain why attorneys who at first blush might seem like they have more speech rights than other trial participants are in fact equal to other trial participants. Seattle Times, I think, already illustrates that a party to the litigation, even a newspaper, can be restricted from revealing comments or revealing any information they've received in the course of the litigation. And so, yes, I do think there is a long history of defendants being subject to restraints on their liberty as a result of the indictment.
But the Seattle Times, that interest is taken care of by a separate order in this case also, right?
Yes, a protective order, yes.
Yes, so that's not really direct support for this kind of order.
It's important because Seattle Times says specifically that when it's even a civil litigant who is a newspaper who comes in information through the court proceedings, then the standard is not kind of the Nebraska press standard. It's not clear and present danger. It's something lower, in that case, just good cause.
Why shouldn't there be three categories? Those outside the trial, for media, but could be other commenters, participants, and the criminal defendant. Why doesn't our history of allowing criminal defendants to vigorously and equipping them to vigorously defend against the government warrant there. I don't think there's any history of regulation. Why doesn't that require something more exacting than the genteel test? Maybe not clear and present danger, but as I asked your friend on the other side, is there anything between genteel and clear and present danger that would be appropriate in your view? Or is it genteel?
We think the genteel standard applies, certainly, and the idea that defendants have kind of a uniquely expanded set of rights as compared to other trial participants, I think is clearly contrary to the long history of making them subject to imprisonment or being held in detention pre-trial, all sorts of restrictions.
Yeah, but being detained requires a showing, a hard actual showing of actual risk of flight or threat to public safety. We're now talking about a type of order that doesn't require immediate facts to issue. That's clear from Nebraska. It's, you said, common wisdom and judgment can be part of the analysis of what's going on in the world. And so, and we live in a free society where it's incredibly hard for government to lock a citizen up. Has to be, because that's the first tool of oppressive governments. And so, to be clear, they need to do it sometimes, and it can be done. But we have set up a lot of, pro-defendant, make it really hard for the government requirements because we don't want to be like other countries. And I'm asking is why that wouldn't include allowing a criminal defendant, for example, to publicly say, that person who just had a press conference denouncing me is a liar.
So my reference to pretrial detention was only to illustrate kind of the most extreme.
Mm-hmm.
But again, if you look at the Bail Reform Act, which I think
the what?
The Bail Reform Act,
Uh-huh.
which encompasses a number of provisions that had preceded that under the court's inherent power, defendants can be made to seek a job, commence an education, have a curfew. These are all standards that couldn't possibly be imposed on a third party to the litigation based on a similar showing. They're imposed because, as a result of the operation of the criminal justice system and the indictment, a defendant's.
Well, and we haven't seen First Amendment challenges to those, but here we have a First Amendment challenge that we've got to grapple with.
Well, I think I would sort of push back on the notion that all of the provisions of the Bail Reform Act are violative of the First Amendment.
I'm not saying they are. I'm just saying that we have a particular restriction here.
Yes. And so I guess
a particular challenge that we have to resolve. And so saying a statute lets you do lots of things is not so much an answer to my constitutional question.
Well, I was trying to answer it in the context of the historical, this is analogous to the analysis in Gentile about the historical practice of regulating attorneys. There's also a similar historical practice about regulating the speech and association rights of defendants that has never been thought to violate the First Amendment. So that's why I think, as Brown explained.
You have no backup higher standard that you would propose?
Well, I think because clear and present danger, as you mentioned in the colloquy with my friend, it's not kind of a clear doctrinal test. It's meant to get at the imminence and the significance of the threat. You see in the Levine case in the Ninth Circuit, I can't remember the exact wording, but it's something along the lines of significant and immediate, which is the standard that actually the district court here found. So I think conceivably you could articulate a standard that was somewhere in between, but because the clear and present danger standard is sort of a malleable one that doesn't dictate a doctrinal test, I don't know that that's necessary. But our view is certainly clear and present danger. Excuse me, clear and present danger is wrong. Mm-hmm. Substantial likelihood of material prejudice is correct.
Thank you very much. We appreciate your extra time.
Thank you.
All right, sorry, Mr. Sauer, we will give you 4 minutes for rebuttal.
Nothing further.
Okay, do you want to stand up in case my colleagues have any questions? Any more questions? No? All right, thank you very much. With that, thanks to counsel for your very helpful presentations and your patience with us, the case is submitted.
Stand, please.
This honorable court is now adjourned until Thursday, November 30th at 9:30 a.m.
Oh man, I was just getting Bill Clinton in there. Then I was going to add George W., but it's okay. We had fun with it. So I'm glad you guys were enjoying it. That was a great idea. I don't remember who said it, but it was pretty funny. Anyway, so super interesting stuff. It'll be fascinating to see what they say. I think the judges were actually asking some really good questions and looking at how not narrowly tailored this gag order is. So we'll just have to wait and see. I don't know how long it's going to take for them to come to their decision, but a good case to listen to. Like you guys were saying, I think some of you had said, like, the First Amendment is really complicated, and it can be, especially when you get court cases involved. So we'll just have to wait and see. That's really all we can do. But thank you guys so much for joining me, hanging out with me. I always love doing this with you. I think it's a lot of fun. It was nice to listen to like an actual court case as opposed to like a congressional hearing, which I love for the soap opera vibe of a congressional hearing. So tomorrow, I think it starts at 10, but I'm going to look and see, is I want to say it's the House Oversight Committee, maybe, or the Judiciary Committee, whatever. One of the two. They're doing a markup, and they're going to be talking about, I believe that's either Hunter Biden about making him in contempt for not responding to the subpoena, or Mayorkas, or it might be both. So we'll have to watch it and see, but I will post it. I'll go and look right after this, and I'll post it as soon as I can, so you guys know when it will be. But hopefully you have a great day. Stay safe, all of you who have the really nasty weather out there. I know Dorothy was saying you're supposed to get like 7 to 9 inches of snow. No fun. So stay safe, stay warm, and I'll see you guys tomorrow. Let me pull up. I wonder if, well, hopefully we'll have more DC Court of Appeals, and I'll have that overlay so the presidents and I could be hanging out with you guys the next time we have an appeals court kind of situation, but that was a lot of fun. Well, thank you, Chris. Love you too. You guys are great. All right, let me pull up a Dave Hurley song so we can just chill out after all that. I promise I'm going to get some new ones made up. I know I only have the 2 so far, but with the new logo. Which, by the way, I don't know that I've said. Let me see if I have it on here. I don't think I've discussed the new profile pic with you guys. Let me see if it'll let me make it. No, it's not going to let me make it too big. All right. I'll bring it up at another time, but we'll go through it. That's actually one of my chickens. That's Eggy Smalls. So actually, wait, hold on. I think I can probably let me see if I can just find it real quick. No, it won't let me do it. All right. I'll have to make like an overlay or something and show it to you, but we'll go through what the new profile pic actually is. But that is Eggy Smalls. She's awesome. And fantastic hairdo, that one. So it's a fun one. I had a lot of fun doing that. All right. I will see you guys tomorrow. Thank you. Bye.
The only time life mattered inside the light, I'll watch the world play. In between the veils, I'd like to stay. Your crazed dark skies, something's new now behind your eyes. Feeling left behind. I wanna know. I'll tell you that I need a longer day to wash my fears away, chase the life I dream, and there'll be much more to show, and I will never know the darker side of me. I wanna know. I wanna know. I'll learn it all tonight. Tonight I'll watch my problems fade away. The only time life mattered, you saw fade. I'll tell you that I need a longer day to wash my fears away, chase the life I dream. There'll be much more to show, and I will never know the darker side of me. I need a longer day to wash my fears away, chase the life I dream. There'll